Good evening, everyone. First of all, I welcome everyone to the Intellectual Property as Security Asset for Credit Issues and Prospects webinar. We'll be starting in another couple of minutes. Our research associate, Mr. Gyan, will be formally starting the session in another 2 minutes.
A very good evening to everyone present here. First of all, excuse us that we had started 5 minutes late today. So on behalf of DPIT Chair on IPR and CIPRA NLSAU Bangalore, we welcome you all for the virtual roundtable on IP as a security for credit issues and prospects. Now, I would like to invite Professor Dr. T. Ramakrishna, Chair Professor at IPR at NLSAU Bangalore, for his welcome and opening remarks. Thank you.
Good evening, everyone. Of course, good morning to our American friends. Welcome to the roundtable, IP as a security asset for credit issues and prospects. With a very brief background to this roundtable, I would just want to welcome the participants and the guests. The National Intellectual Property Rights Policy, initiated by the Government of India, right? It was launched with about 7 objectives, which most of us are familiar with. The IPR that is created should be capable of being utilized as an effective tool for both social benefit as well as for economic growth. In addition to monetizing through licensing assignment, IP also has the potential of being used as a security interest. IP has financially significant and distinguishing characteristics. So like the intangible nature, limited duration of protection, and limitations on IP in the public interest being notable amongst them, they mandate a different treatment for it in all the transactions. IP, as we know, has gained economic importance and is recognized as an economic asset in India and elsewhere. Though not an asset with all the legal and economic characteristics of a security asset to the perfection, IP has most of the features, and an adequate legal framework can attribute certain features of security asset to IP. We should examine whether it is present in the Indian ecosystem or not. IP secure transaction has 4 main aspects on which we are going to debate today: due diligence, creation of security interest, perfection of security interest, and of course, the 4th aspect is the enforcement of the security interest. As regards the due diligence for secured financing, it's an investigation prior to entering into a contract or an act with a certain standard of care, and it serves to confirm all material facts in regard to the transaction. The primary purpose of security, as all of us know, is to reduce credit risk and obtain priority over other creditors in the event of the debtor's bankruptcy or liquidation. IP due diligence is essentially an audit to assess the quantity and the quality of IP assets owned by or licensed to a company, a business, or an individual. This is to assess the value of assets involved and also to evaluate the risk involved in the transactions. We know there are different methods of valuation of the IP, and of course, the most recognized methods are market method, the income method, and the cost method, to which in the course of our debate we might be going into. Moving on to the security creation. The existing legal framework for security creation in India is to be understood by looking at the provisions for security creation in general laws other than the intellectual property laws, as well as modes of security creation recognized in IP laws. The adequacy of present legal framework needs to be examined. On a survey of present forms of security recognized under intellectual property laws, and of course the general laws, it can be found that the security recognized presently are mostly asset and necessity specific, be it mortgage of immovable property, mortgage of movable, charge of immovable property, hypothecation, pledge, lien, or assignment of actionable claims. In fact, the system of floating charge, as it is practiced now, also has problems if applied to intellectual property security creations. Well, the next aspect is perfection of security interest. As we know, when a security interest is created, it becomes enforceable against the debtor. But the existence of the security interest will not necessarily be known to a third party who is proposing to acquire an interest in the asset or to other unsecured creditors. So to secure the interest of such persons, law usually requires the secured party to give some form of public notice. This requirement of public notice is known as perfection requirement. The methods by which a security interest can be drawn to public notice vary according to the type of interest created. They do not all operate in the same way, nor is reasoning behind their effect always the same. The law has long exhibited deep suspicion of secret liens that do not put their parties on reasonable notice of financing. The earliest personal property financing arrangements therefore required actual delivery of the collateral to the creditor. Of course, gradually, various forms of non-possessory security devices were recognized. And in those cases, of course, with rare exceptions, a public filing was required as a condition of protecting the creditor against fraudulent conveyance. See, the purpose of system for perfection is just to avoid fraudulent transactions. It's also to give unsecured creditors and the public or third parties who are interested to deal with secured asset about the existence of encumbrance. A survey of perfection system shows that there are mainly two kinds of systems recognized in India. First, the possession or control-based perfection system. And the second one, registration or filing or noting-based system of perfection. However, it's found that none of the systems are appropriate for perfecting security interest in possible intellectual property secured transactions. Let me just move to the final aspect, that is the enforcement of security interest in IP. A financier or a lender, right, taking security for advance will at least be able to look to his security to obtain a total or a partial payment. So the very purpose of taking security is enforcement of security interest. The matter of enforcement of security interest arises when the repayment or other obligation under credit agreement is faulted, right, by the borrower, or when the insolvency or bankruptcy or winding up or liquidation proceeding is initiated against the borrower. Generally, we can contemplate three different situations. Situation number one, there may be default without an insolvency or bankruptcy or winding up or liquidation proceedings. That's the first situation. Second situation, there may be insolvency or bankruptcy or winding up liquidation and default happening together. And the third situation is there may be situations where insolvency, bankruptcy, winding up or liquidation proceedings initiated, even when repayment or other obligations under credit agreement is not defaulted. You know, in the first and second instance, security interest will have to be claimed and realized. Whereas in the last situation, if the insolvency representative or the administrator or the liquidator, as the case may be, rejects the contracts in relation to the credit and security, enforcement becomes necessary. However, if they do not reject the contract relating to credit and security, the security holder or the lender will have the option of continuing with credit arrangement and security rights. Well, friends, in the backdrop of these complexities and concerns, the DPIIT Chair on Intellectual Property Rights of National Law School of India University and the Center for Intellectual Property Rights Research and Advocacy of NLSIU thought it fit to organize this roundtable conference and understand better the scheme and structure, both legal and regulatory. We are happy to welcome the chair, who I'm sure has joined us, of today's inaugural session, Professor Sudhir Krishnaswamy, who is the Vice Chancellor of National Law School of India University. He has been always helpful and has been taking proactive initiative to promote research and developmental activities of the research centers. Welcome, sir. We are blessed by the presence of my great friend, Dr. Raj Dave. Perhaps to introduce him, we may have to take the entire session. But I just would like to say that he is a highly reputed patent attorney in US and many other countries, who has led several IP delegations from US and other parts to India. Of course, I feel proud that the first one was a visit to NLSAU way back in 2003 and 2004. Raj Dave has been spearheading the Patent Facilitation Center of the Department of Science and Technology. I have been working very closely with him on several activities, and it is always a pleasure, right, and to work with him. We heartily welcome you, sir, to this particular program.
Thank you.
We are highly obliged to our resource persons who have, despite their commitments, have agreed to share their thoughts and experiences on this occasion. We have with us Mr. Navare Roy, the Managing Associate of Anand & Anand, who agreed and accepted our invitation and will be speaking on IP due diligence and valuation for secured transactions. We welcome you, Mr. Roy.
Thank you. Thank you very much.
We have with us Mr. Anandade Mishra, the founder of AM Legals, who agreed to speak on creation of security interest in IP asset. Welcome, sir. Welcome for this particular program.
Thanks.
Welcome, sir. We have with us Professor Sudipta D. Sarkar, who is a professor at the KIT School of Law, Bhubaneswar, who has agreed to speak on perfection or registration of security interest in IP asset. Welcome, Sudipta, to this program. And Mr. Pramod Rao, right, the Group General Counsel of ICICI Group, has been kind enough to accept our invitation and share his thoughts on this particular occasion. And he will be speaking on the most important critical part, the enforcement of IP assets, security interests. And today we have another great friend from US joining us as a special guest speaker of the day, who is a partner at Pillsbury, San Francisco, Mr. Philip S. Warden, who has agreed to share his experience on issues from US perspective. We heartily welcome you, Mr. Philip S. Warden. While welcoming all the learned speakers, we wholeheartedly welcome the participants, right, who have responded to our invitation in large numbers. Perhaps this is an indication or a pointer to the relevance of the topic in the current scenario. With these few words, I welcome everyone and thank all of you for having participated in this particular program. Over to Anna.
Thank you so much, sir, for your warm welcome and opening remarks. Now I would request Mr. Divyesh Pratap to introduce and welcome our keynote speaker. Thank you.
Thank you, Gyan, for giving me an opportunity to speak our speaker for the keynote address. We have with us Professor Dr. Raj Dave, who is the president and founder of Dave Law Group, heading a head office opposite to the United States Patents and Trademark Office in Virginia, United States of America. He is the Gujarat Council of Science and Technology Intellectual Property Rights Chair Professor at Gujarat National Law University. He has lectured in multiple countries and taught courses on innovation and patent law in China and India. He is the chairman of the Patent Facilitation Committee of the Government of India. Dr. Dave focuses on intellectual property counseling, patent prosecution, dispute resolution, licensing, technology transactions, intellectual property mining and enforcement, re-examination and reissue practice, pre-litigation opinions, and patent litigation. He has formed strategic alliances with major investment groups to finance patent litigation. Dr. Dave is an expert in biopharmaceuticals and represents several drug companies. He has also assembled a highly experienced team of experts from a cross-section of key practice areas, including FDA, regulatory, ANDA litigation, technology transactions, and trade secrets. I request on behalf of National Law School of India University, Professor Raj Dave to deliver the keynote address for today's program. Over to you, sir.
Thank you very much. Can I share my screen, please?
Please, sir.
Okay. Can you see my screen?
Yeah.
Thank you. First of all, I think this is a very appropriate time in India to talk about IP as a security asset. This is something that's very commonly being done in the US in the last 15 to 20 years, more so in the last 10 years. And this area is one of the most difficult and complicated areas of law. And I would say why? Because you need to combine two very difficult areas of law, bankruptcy and IP, besides contract, etc. And so let me throw in front of you or present in front of you two possible scenarios. Okay. Scenario one, and let me make the screen a little bit bigger. Scenario one is the owner O sells IP to buyer A. Okay. Subsequently, owner O declares bankruptcy soon after the sale. And later, the bankruptcy court rejects the sale of the IP. Actually, if you notice, even during the preliminary talk by Professor Ramakrishna, he did talk about the word rejection, etc. Let's also look at a second possible scenario. Owner O sells IP to buyer A. Later, owner O sells the same IP to buyer B. These are real practical scenarios that happen in real life. Especially when you look at the scenario two, where buyer sells IP, owner O sells IP to buyer A, he later sells IP to buyer B. Guess what? In that scenario, there may be no fraud whatsoever. It happens that IP is simply nothing but numbers in terms of what is the patent numbers, etc. And the owner may very well be confused and may have sold the same IP to buyer B. What do you do in scenarios like these? In order to understand the relationship between bankruptcy and IP as it pertains to security interest in IP, you need to understand a few very fundamental concepts. Concept one is notice. Notice is the legal concept describing a requirement that a party be aware of legal process affecting their rights, obligations, or duties. There are several types of notice: public notice or legal notice, actual notice, constructive notice, implied notice. The second concept is recordation. Recordation is the act or process of recording an instrument, such as an assignment, deed, or mortgage in a public registry. The third fundamental concept is the law governing recording act. It's the law that determines which party prevails when the same IP is transferred to multiple people. The other important concept is the concept of a bona fide purchaser for sale, for value. A buyer who pays fair consideration for IP without any knowledge or reason to have knowledge that the seller previously transferred the IP to a different person, he is considered a bona fide purchaser for value. Okay. And the fifth important concept that you need to all understand is the concept of jurisdiction. Okay. what is the type of jurisdiction in which you are operating? The three possible types of jurisdictions. Notice jurisdiction. Notice jurisdiction is that a jurisdiction whose rule allows a subsequent bona fide purchaser to prevail over an earlier purchaser if the earlier purchaser's deed was not recorded and the subsequent purchaser did not know of the earlier transfer. Okay, that's the notice jurisdiction. We then have what's called the res notice jurisdiction. That's what is the jurisdiction in the US, res notice. A res notice jurisdiction is a jurisdiction whose rule allows a subsequent bona fide purchaser to prevail over an earlier purchaser if and only if the subsequent purchaser did not know of the earlier transfer and the subsequent purchaser's deed was recorded before the first purchaser's deed. Okay. And then last we have the res jurisdiction. This is where a jurisdiction whose rule determines which party prevails in a twice transferred IP case, strictly on the basis of whose deed is recorded first. So let me show you an hypothetical. Hypothetical is owner O sells IP to buyer A on January 1, 2020. Now buyer A files for recordation on January 31st, 2020. Inadvertently, and I use the word inadvertently to show that there has been no fraud, okay? Inadvertently, owner O sells the same IP to bona fide buyer B on February 1, 2020. The government issues a public notice of recordation, and I use the word government because it depends on which entity of the government is doing this, or basically public notice of recordation to buyer A, and it's public because others can also know that the notice has come out on February 7th, 2020. So if these are the facts, okay, is buyer A or buyer B the rightful owner of the IP? Okay, so now let's look at the notice jurisdiction. If you had the notice jurisdiction, did buyer B have notice on February 1st when he purchased, he is a bona fide buyer, when he purchased the IP from owner O? The answer is no, he had no notice. There was nothing was there which was for him to know. So under the notice jurisdiction, buyer B will be the rightful owner in this scenario. Now let's look at the res jurisdiction, okay? Under the res jurisdiction, the buyer A did file his recordation on January 31st, before buyer B had bought it. So there's no way that the buyer B could even have filed for the recordation. So under the res jurisdiction, buyer A will succeed. But what happens under the res notice jurisdiction? There, it depends on what the res notice jurisdiction statute is. In the United States, that's what I'm aware of. In India, there would be its own. You can record and perfect security interest under both federal law and state law, okay? And for federal law, you can perfect security interest in patents, you can perfect security interest in copyrights, you can perfect security interest in trademark. And these are the statutes. For patents, it's 35 USC, US Code 261, Section 261, copyright 17 USC 205, and trademark is 15 USC 16, 60, Section 10, okay? But you can also record and perfect your security interest under the Uniform Commercial Code in each state if you want to, by filing the papers at the Secretary of State. So now let's quickly look at the hypothetical I gave you. With respect to patents, the law is an interest that constitutes an assignment, grant, or conveyance shall be void as against any subsequent purchaser or mortgagee for a valuable consideration without notice. That keyword here is without notice, okay, unless it is recorded in the Patent and Trademark Office within 3 months from its date or prior to the date of such subsequent purchase. And if you notice, in copyright, it says 2 months, okay? And trademark, again, it says 3 months. So what does it mean? That let's say, going back to our hypothetical, the buyer A buys it on January 1st, 2020. So he has up to 3 months for trademark and patents to record in the patent office, okay? And in this case, he did, and for copyright, he has up to 2 months to record. So he did record within 3 months or 2 months by recording it on January 31st, okay? So who wins in this case? Clearly buyer A wins under the race notice jurisdiction, period. But he also has recorded it prior to the B even possibly recording it. So clearly under the race notice jurisdiction, buyer A will win. Now the question here comes up is, how should either buyer A, even if buyer A is buying something, how does he know that or buyer B is buying this IP? How does he know if there is somebody else who has already bought it? Possibly there is not much way to do that. There's no way if there's nothing is yet in public. And especially because buyer A gets 3 months to record, okay, patents and trademarks, and 2 months to record for the purpose of copyright. So what should buyer B be doing? Buyer B should make sure that he has really all sorts of bells and whistles in his contract, including the possibility of escrow, that the money should not go to owner O for at least 3 months from the date of the purchase or the sale of to buyer B. That's one way that buyer B can make sure that once 3 months have passed and the money then gets transferred from the escrow to the owner, he's possibly secured. Okay, I think I will stop here, and I just wanted to just walk you through the nuances of these type of IP asset transfers. Now, what I want to do is my former partner, Phil Warden, and I worked on a real situation where we had hundreds of patents which were and there was security interest. He will be the last speaker, and he will walk you through the real life example that we had faced in back about 10 years ago. Okay, I think that's where I end, and I would like to again welcome everybody and thank everybody for giving me this opportunity. Thank you very much.
Yes, thank you. Thank you, Professor Raj. Thank you for your insightful keynote address. You have explained in a very, very simple way what are the various issues and what are the various concerns which are related to IP as a secured interest. Now, I have the opportunity to introduce our Vice Chancellor, Professor Sudhir Krishnaswamy. Professor Sudhir is the Vice Chancellor of National Law School of India, University, Bengaluru. Previously, he was a professor at Azim Premji University. He was also the B.R. Ambedkar Visiting Professor of Indian Constitutional Law at Columbia Law School. Professor Sudhir graduated from the National Law School of India, University, NLSIU, Bengaluru. He read the BCL and obtained a DPhil from Oxford University. He has been a teaching fellow in the law at the Pembroke College at Oxford University, an assistant professor at NLSIU, and a professor at the West Bengal National University of Juridical Sciences, Kolkata. In the past, Professor Sudhir has also worked in the Prime Minister's Committee on Infrastructure and the Kasturirangan Committee on Governance of Bengaluru. He has authored a book titled Democracy and Constitutionalism in India, which was published by the Oxford University Press in 2009. His main areas of interest are constitutional law, legal education, legal theory, intellectual property law, and administrative law. I welcome you and I invite you to give your presidential remarks, sir.
Thank you, Divyesh. I trust you can hear me. Good evening, everyone, and thank you for joining us this evening. Professor Ramakrishna has taken a renewed and big interest in pushing our work in intellectual property law, and I thank him for it. And I think the point that we are all convened here today to discuss a technical and important topic in intellectual property law convinces me that we're pushing in the same direction. In NLS, there has been a sustained interest in intellectual property issues right from the genesis of the university. The university happened to come into existence at the time that India was contemplating an entry into the TRIPS agreements. And the university has been a part of that thinking through of intellectual property law and the emergence of intellectual property law into the scale and prominence that it enjoys today. And I'm very glad that, as we work our way into the third decade of the 21st century, we're making a renewed push to both be at the cutting edge of the interface between law and technology issues generally, and the aspects of intellectual property that deal with these questions. So, this roundtable is important for us and important for the work that we propose to do in the years ahead. So I thank him once again for the initiative, and thank all of you for taking the time to be here, and to Professor Dave for getting us started on a very focused and thoughtful way. One is struck today by the pervasiveness of IPR discussions across various terrains, and with the ongoing COVID pandemic, it calls on all of us engaged in these issues to think substantively about the ways in which IPR seems to invade domains of everyday life, and some might dare say control important outcomes in our public lives. And thinking through problems of incentive for innovation, and then the problems of distribution of innovative products are going to occupy all of our attention as we move from 2020 to 21, and hopefully participate in the unwinding of the global pandemic. But the question that we have for us today reminds me, and as someone who's taught property law and intellectual property law for some time, reminds me of the intricacies of the early debates on rules of priority in land interests in English law. And I'm talking about debates that go back a good, some might say the 1500s, but at least let's agree the late 1800s, as land is being settled and resettled in England. Very complex rules develop around the cadaster, and how the recording of property interests and its relative priority to use interests that might exist in the land, generated a sort of intellectual and legal ingenuity and creativity at that point. And it seems that the kind of question that we are asking in this panel deals with similar questions of type, questions of priorities of time, priorities of interest, and priorities of recording of interests, right? and whether those questions get raised in the context of insolvency, or whether those questions get raised just in a due diligence transaction where intellectual property is involved, would raise all of these in intricate and difficult to solve ways. And I recall that what is very useful in this very difficult rule framework is to constantly think back to what kind of optimal or efficient design might be necessary in these kinds of environments. And I'm struck by the curious use of some pretty advanced new technology, blockchain technology, to advance new methods, almost to develop. And I'm going to stretch out the metaphor a little bit, almost to develop a torrent-style recording infrastructure for movable property, and this promises, and I'm not holding out that this is a resolution for many of the questions that were raised, but it promises to address many of our questions about priority of time, as well as about ensuring that we don't have the problems related to asymmetric information around transactions, legal transactions around property. So the problem of security interest and priority with movable property has been a problem that's been with us for a long time. But the questions arising out of intellectual property might bring some particular nuance and difficulty to these problems. And I would and my appetite is whetted just by the short panel that I've been a part of. I would imagine that many of you who have done far more work in these fields will educate us and deliberate in the next few hours, working through what might be interesting and plausible, possible resolutions of these problems in our time. So let me stop there and hand it back to Devesh or to Jnana to move things along. Thank you very much, and look forward to hearing more.
Thank you, Professor Sudhir. Thank you for taking out time from a busy schedule and addressing the gathering. Now I invite Dr. Lawal Mann to deliver the formal vote of thanks for the inaugural session.
A very good evening to one and all. We are concluding the brief inaugural session of the online roundtable, the technical session of which is going to follow, which is jointly organized by Department for Promotion of Industry and Internal Trade, Government of India, and Chair on IPR in National Law School of India University, Bangalore. As we have a very tight schedule, let me move to the duty cast on me. The inaugural session is presided over by Professor Dr. Sudhir Krishnaswamy, Honorable Vice Chancellor, National Law School of India University. Professor Sudhir is a scholar of eminence and man of words of wisdom. It is his patronage that made this program possible. On behalf of the organizing committee, I thank Professor Dr. Sudhir Krishnaswamy for his presence and words of wisdom. Thank you, sir. The keynote address, which set the tone for the technical session that is to follow in the inaugural session, is delivered by Professor Dr. Raj Dave, a personality of international repute. Dr. Dave has a lot of experience in the theme of Roundtable, which sir would definitely share with us. On behalf of the organizing committee, let me extend a vote of thanks to Dr. Dave. We also have Professor Dr. Ramakrishna, who conceptualized the idea of the roundtable on this particular topic, which is of course technical as well as very important, and giving his guidance all through. Thank you, Professor Ramakrishna, for conceptualization and being with us to organize this program. The idea is being translated into a reality. We are just seeing that. Now we are moving to the technical session. As the participants already know, we have 4 sub-themes. The first one is on IP due diligence for the purpose of secure transactions. The second sub-theme is on security creation in intellectual property rights. And the third one is on perfection or registration of IP security right, which is already created. And the fourth one, of course, the very purpose of security creation, that is the enforcement of IP security right. These are the four sub-themes for us. And we have eminent personalities to speak on each of these topics. If you look at the speakers list, we have a mix of industry, academia, and profession. And the Professor Dr. Dave would be chairing the session on behalf of the organizing committee and all of us. And on my own behalf, I request Professor Dr. Dave to take over as chairperson of the session. Thank you one and all once again. And over to you, sir. Over to Dr. Raj.
Thank you very much. Can you see me?
Yeah, yes.
Yes.
Thank you very much. So I'd like to have the first speaker start, and because we are running late, I'd like the first speaker to just let's get started.
Hello all. I would like to take the opportunity to introduce our first speaker, Mr. Navare Roy. He's the Managing Associate at Anand & Anand, Chennai. His practice includes the prosecution and enforcement of the different streams of intellectual property before the appropriate IP offices, the IP Appropriate Appellate Board, the appropriate civil courts or criminal proceedings. He has worked with the individuals and businesses from startups to Fortune 500 companies in strategizing, protecting, and monetizing their intellectual property and commercial interests. He has also acted on behalf of businesses in the retrieval of domains from domains quarters through the appropriate INRP or UDRP proceedings. He is regularly involved in the audit and valuation of IP assets of various entities and recently concluded a transaction involving the valuation of audio and video content rights owned by a media and entertainment company. He is also a visiting faculty of the Madras University, where he conducts classes on copyright for postgraduate journalism students. I welcome you, sir, and over to you.
Thank you very much. Thank you to CIPRA and NLSIU for putting together this session and to put together this roundtable as well. I do understand we're running a little late, so I will jump straight through to the presentation that I've got prepared. And broadly speaking, the session that I will be dealing with is specific to IP due diligence and valuation, particularly for secured transactions. Since I do understand the audience is fairly well versed with IP, and it sounds that the session is going to be fairly technical, I did keep it quite simple though. So do bear with me if you find it a little oversimplification of certain things. What I do hope to sort of speak about and cover today is, one is in terms of shifting of our view of IP to viewing IP as an asset. The second is with regard to audits and due diligences as to what we need to be looking at from a general property perspective, like Professor Sudhir spoke to specific to an IP perspective as well, and specifically with regard to valuation, and sort of end things up with a very quick example of a transaction that I was recently involved in. Right. So this is just broad overview of what I'm looking at. And in terms of, just jumping right in, traditionally intellectual property has always been seen as, a way. I've got two images on the screen, as you can possibly see. Both do involve walls. I'm not particularly, I'm not showing support with any particular part in the United States, but broadly, there are two walls over here. And one on the left is the Great Wall of China. And this predominantly, I would say, is the view that most people have with regard to IP. One is you carve out your exclusivity within what you've got, and you make sure you're not stepping on somebody else's toes vis-a-vis infringement, right? So it's a way of just demarcating one place to the other. What's mine versus what's yours, right? Whereas on the right, we've got the wall, which is encompassing maybe a farmhouse with a farm. And this is the sort of thing where we've got an enclosure, you've got land, you've got things on it which generate revenue, right? This is a simple shift that we need to look at when it comes to IP. There are certain jurisdictions that view IP as an asset far more than maybe certain other jurisdictions. And in India, I think we're slowly getting to the place where we're actually viewing IP as something as more of an asset rather than just a tool of competitive advantage, which IP originally was conceived as. So the first thing, if you do move into this view set, if you do look at IP as an asset, right? The first thing that we need to look at when you're doing any due diligence exercise, and we do get a lot of cases where people claim that they've protected and filed their right applications. But the first thing is to identify whether what has been protected or whether the steps taken to protect are actually in the right bucket. Now, there are different streams of intellectual property, trademarks, patents, copyrights, and designs, and I'm sure most of you are all aware of this, but each of them have their own rights and limitations. Each of them have their own advantages. Some of them overlap with each other. So if they do, the most important thing is to identify whether the correct steps have been taken to identify the right bucket. If your basis and your business is based on goodwill, have you protected your trademarks? If your basis is on aesthetic appeal, have you protected your designs as opposed to just letting them go on the basis of copyright? When there's an overlap, which one do you choose? Why do you choose one over the other? Right? It's absolutely important to see which bucket or which stream of intellectual property you've chosen to protect. And that is one that gives you the most protection, right? So you very often, and each of these different streams have different obligations when it comes down to procedure, when it comes down to disclosure, before filing and then going ahead. Different jurisdictions have different rules as well. So it's absolutely important to identify whether or not what is there as an asset has been identified appropriately and protected, and necessary and correct steps have been taken to protect those. The next thing that you need to look at, as with any transaction involving securitization, would be due diligence in terms of ownership. Does the person who claims to have the IP or the asset actually in fact have the asset, right? Very often you'll find if you're looking at it from a startup side, more often than not, there'll be individual directors or partners who try and hold and register all the IP in their individual capacity in their name, not necessarily in the capacity of the company or the entity that they've created for it. Sometimes you'll end up finding that there are holding companies and subsidiary companies and related entities. Who actually owns what is a very, very important aspect to look at, right? And also with regard to assignments and licenses, a lot of these rights, as I think Dr. Dave as well spent some time explaining that initial example, what happens if there is rights which have already been assigned away, or rights which have been assigned but not notified, right? So, and licenses which have been granted. It's absolutely essential to identify whether ownership of the IP in fact vests with the entity that you're looking at and the entity which is looking to raise capital in this case. The next thing is also in terms of strength and quality of the IP. It's not just good enough if you've gone ahead and filed or registered your trademark or patent or copyright or design. The actual quality of what you have is absolutely essential. So I'm just going to take an example of, this is fairly often used with regard to prior art and patents, and there are stories about it, and to the veracity, I'll leave that to, there are certain articles on the veracity as well, but broadly put, there was sometime in 1964, there was a ship which capsized within the Gulf and near Kuwait, and you had about 5,500 sheep which apparently got stuck in the cargo hold and went right down to the base. Now, given that this was drinking water related and reservoir related, they had to get the ship out as soon as possible. So we've had Carl Kreuer, the Danish inventor, who decided to pump in about 27 million plastic balls through a pipe all the way down to the ship, which would make it buoyant and therefore bring it up to the top, right? So he accordingly went ahead and filed a patent application as well. And the theory and the story is that the Danish Patent Office refused to grant that patent on the ground that there was prior art to it. And the prior art in this case was actually a comic book strip which came out a couple of years ago, involving Donald Duck, and Huey, and Louis using the same concept to bring about a sunken yacht. Right. So the idea is prior art. Even if there is someone, if you're doing a due diligence exercise for someone who has, say, come to you with a patent application, it would be worthwhile to do your own prior art search as well to see whether or not there is a likelihood of that right being granted in the end. It's not just good enough that they've got an application in place. The actual merit comes down to the strength and quality of it, right? So the next example that I've also got is particularly interesting when you've got cross-border issues at hand. So over here, we've got the bus on the left, which is Irizar, and on the right was Swaraj Mazda and Isuzu. So the bus design on the left was originally filed as a design application in Spain and then brought into India. And then the Irizar did find out that there were multiple buses ready for being sold by Swaraj Mazda. And so they approached the court seeking an injunction against them. But so what invariably happened, and they relied primarily on their design rights. So if you look at it over here, they had a design registration granted originally on the left, which you will see. And they've also got a design registration or a certificate for design registration here in India as well. So on the basis of it, they should have had a good claim. But here's the thing. On the left, if you see, there's a small date over there in which they had filed their application, and that was in February, 12th of February of 2001. And they filed their application in India on 9th of August, 2001, which is still before 12th of August, which is when you claim priority from. But there was one problem in that while filing the Indian application, filing the priority application in India, they forgot to claim priority from the original or the home design application. Given that they hadn't claimed priority from the original application, their application in Spain became prior art, and therefore this design was not novel on Indian soil. And given that it was not novel on Indian soil, they did not have the right to enforce their rights against a third party whose design might have been considered similar. So this is something that, even again on paper, both have designs granted. You've even got registration certificates, but the veracity, the validity, and the actual strength of the IP has to be tested. And that is something that you need to look at when you're doing a due diligence exercise. It's you need to go in deep and to see whether or not there is prior art, whether or not there is exclusivity, in fact, whether or not this could stand in a court of law, because ultimately these are tested only when there is a contentious matter or when there is something that there is a dispute involved and one needs to rely on one of these rights. So the exercise, when it comes down to IP, now when it comes down to a land transaction where you're just looking at property from a valuation perspective and doing your due diligence, you have straightforward, you have the authority that says, okay, fine, there's no encumbrance, and that's it, there's only on encumbrance. Whereas here, the actual, the value of the property or the intangible asset is also a moving target, so to speak, because it's not fixed. It's not, you don't have XYZ criteria, which if you tick off the boxes, it's done and dusted. Like for this case, you would have the registration certificate in hand, whereas it wouldn't have really counted for much. So getting down into the nitty-gritty, identifying ownership, identifying actual strength and validity of a particular asset, that's an important exercise which is unique to an IP due diligence, and that's something that we need to look at as well. The next one is, okay, so you've gone ahead, you've identified that ownership is right, rights are protected, fair enough, everything seems to be in shape. You need to come and ascribe an actual value. And this one, as Professor Ramakrishna as well mentioned, these are broadly the accepted valuation methods, even according to WIPO, and there are several other institutions who have used these three methods, which is your income approach, your comparable market or the market method, and the cost approach. So ideally, income is you're predicting the income that is going to come in through the utilization of that particular asset. So if it's a patent, this could be with regard to the revenue that you're looking to get back either through direct sales, or it could be even through licensing it out. Comparable market or the market method is where you analyze similar transactions. So if there was a sale of a similar IP asset, a similar patent, or maybe a similar copyright album of music, then in that case, you have a broad range of where you need to start. And the cost approach, of course, is where you evaluate the actual, the money and the effort that has gone into creation of it, a creation of a particular asset, and either the charges or the cost to replace that, or to build that up from scratch. So with this, you come up with a value for the asset that you've got, right? And so when it comes down to this particular thing, there are certain specific issues or specific unique things, aspects of intellectual property, which is different from your general tangible assets, right? And one, of course, is with regard to period of protection and the value over time, right? So when you look at trademarks in theory, protection could be perpetual because you can keep renewing a trademark as long as it's in use, right? And goodwill accordingly could potentially increase over time. Of course, you've got a scenario where if you become so vast and if you become so well known that your trademark could also face genericide, in which case your value goes back down lower. So depending on which end of the curve you're looking at, the value could either go over time or it could decrease over time. With regard to patents, even though there is protection for about 20 years, you need to look at technology lifestyle. So even though you do have 20 years exclusivity, say in a jurisdiction like India, technology adoption has been steadily increasing. So which means the use of technology, which is considered cutting edge, may be obsolete far quicker than the actual entire lifespan of your patent. So in general, you're looking at it as maybe about 4 or 5 years is all the exclusivity or that you may need, not that you may have, but that you may need, right? And at the same time, when you look at copyright, you've got lifetime of the author plus 60 years in a jurisdiction like India, or a minimum of 60 years. And this sometimes could increase over time. Again, depending, say, for instance, an artist and their work over time invariably increases, you could also have it decrease. So it's a factor that needs to be looked at. So it's not as straightforward as, having an income method or a cost approach or a market method. You need to also understand the beast that you're trying to value. And that is something, so you've got several factors. One, of course, is this. And if you look at designs as well, designs, again, 15 years in an Indian context, but could possibly decrease over time as well, because what's aesthetically appealing changes, it could last as well. So this is just one factor when you're looking at. In addition to this, there is the strength of the IP protection that you've got, the exclusivity, jurisdiction agnostic. Do you have protection in multiple countries? Is it only in one jurisdiction? In terms of how far down the life cycle are you? Do you have, are you in your 16th year of patent protection? Then in that case, how much further do you actually have to gain any amount of monetization out of it? So it's something that there are a lot of moving parts to, and it's not a specific science. There are a lot of variables involved, and someone who, that's why it's important to take a lot of these factors into place. Unlike traditional asset valuation, having so many moving parts is something that makes it difficult for these sorts of transactions. But that said, we are moving towards an economy, we've already moved to an economy which is predominantly IP-led and knowledge-based. And it's absolutely essential, which is why this roundtable and events like this are great, because we need to start viewing IP more of as an asset that can be used for monetization. So with that, I'm just going to move into this particular example that we've which was a recent transaction that I was involved in, which was valuation of the intellectual property assets, in this case, predominantly copyright of a particular media-based company based out of here in India. The main purpose of it, of course, was to assign all the rights involved into a Singapore entity because they wanted that to be a holding company. So in terms of this, they had intangible assets. Yes, they had content on 79 YouTube channels. They were doing commissioned web series. They had acquired the rights to over 275 songs from different movies. The important thing in this, of course, the exercise on this predominantly was on the due diligence front, because each of these contracts, each of these rights vest with, since it dealt with copyright, and copyright is something that exists the minute it is created, in addition to actual registrations that they had, a lot of this involved actually going down to who owned what rights, and particularly in the rights which were acquired. Very often, you will have, there were rights, particularly for specific songs, where the streaming rights had gone to one particular company, the mechanical and synchronization royalties had gone to somebody else, and when it came down to ringtones, when it came down to actual streaming of music, there were just so many different channels, and it's great from a creator perspective because we've got different streams of revenue coming in. But when it comes down to identifying who owns what and do all those rights actually still vest for them, a lot of this just comes down to agreements. And what happens if you are acquiring these rights? Has the person actually disclosed all their sub-licenses or their licenses down, right? So it's needless to say, it was a very interesting task, and it's something that I think is definitely going to pick up, because there are a lot more content-based businesses in place, and overall, whether it's technology or whether it's arts and content, whether it's just goodwill and branding, IP is definitely an asset, and it's something which we're going to have to view differently, at least from an Indian perspective. So I think with that, I'm going to just close my bit of the session, and I'll leave it to the rest of the committee and the rest of the team to go on.
That was a very good talk, Navari.
Thank you.
Maybe can I ask a quick question?
Of course, certainly.
When you did this copyright-related case, I can understand due diligence was done by Anand and Anand. Was the valuation also done by Anand and Anand, or did you guys hire a separate financial team to do that?
Right. So we did in fact engage with a financial team, because obviously this requires, so we were more on the testing of the strength of the actual IP, like I was explaining earlier, but we did need to tie up with the financial team as well. And I've been fortunate enough to do a course on IP valuation by WIPO. So I was at least able to sort of figure out whether or not we were on track. But broadly put, you need to leave it to the experts who have the financial backing to do the.
I thought so. So
Yep.
Just what you basically described two very important aspects. One is IP due diligence. The second one is IP valuation. At least I have worked in the cases that I've dealt with. As a lawyer, I never delved into the valuation side. That was always left to the people from the big fours who would or one of these accounting firms who would do the valuation. We would only do the due diligence. Now, even when it came to due diligence, actually, what you said is absolutely correct. I'll give you two extreme examples that I've dealt with. One was the sale of a complete computer company, okay? Huge computer company. And literally there were thousands and thousands of patents, okay?
Mm.
And then there was the other extreme, it was a biotech company where there were a few patents, but extremely critical patents.
Mm.
In the case where there were literally thousands of patents in the computer company, all we did was, are these ownership still valid, titles are correct or not, okay? Because there was no way that we could go into thousands of patents and see the validity. When we looked at the biotech, where there were a few patents, but very critical patents, we actually scrubbed every patent, every claim to make sure that the patents are valid. There's no issue about validity, no issue in terms of somebody having given internally also an opinion that there were problems, etc. We went through, asked them for, do you have any opinions, etc. So I just wanted to let you know that depending on what type of a deal it is, it could be the type of due diligence you end up doing can be very different.
Of course, absolutely. You're spot on, because the more ground you have to cover, again, it comes down to the purpose, like you
Exactly.
said, the purpose of it. And yes, it could be.
But very good presentation. Thank you.
Thank you very much.
The next speaker. So our next speaker is, Mr. Mishra, and Aishwarya, can you please introduce Mr. Mishra, please?
Yes, thank you very much, sir. Our next speaker is Mr. Ananday Mishra. He's the founder and managing partner for AM Legals. He's a litigation and arbitration practicing advocate. He's an advocate on record in Gujarat High Court at Ahmedabad. He regularly appears in High Court of Gujarat and Maharashtra beside other High Courts of India. He's also appearing in the Supreme Court of India. He has led diverse legal assignments in various laws in the last 2 decades. His focus areas of practice are arbitration, domestic and international, GST or VAT, indirect taxes, insolvency, company law, contract laws, IPR, insurance and reinsurance, mergers and acquisitions, and white-collar offenses. He appears in various High Courts of India appellate tribunals like NCLT, CSTAT, and DRT, civil courts, prominently for insolvency and bankruptcy, arbitration, indirect taxes, contract laws, IPR, commercial laws, and civil law matters. He handles various domestic and international arbitration seated in India, Singapore, UAE, Hong Kong, and London. He has authored the book GST Law and Procedure for Taxmen. He's presently authoring books on IBC and arbitration. He's written hundreds of exhaustive and well-researched white papers on various areas of law. He's a regular speaker at various forums, conferences, and meets on GST, arbitration, contracts, IPR, and IBC. I formally welcome you, sir, to take over.
Thanks and good evening. It was a very nice session so far. A lot to be learned from all the dignitaries, speakers. I will straightforward take to my topic. I'm not presenting any slide. Time is also very less, and the topic is very exhaustive, but I will try to curtail it in a very few words. Of course, as soon as anybody says that the creation of security in IPR assets, I say let intellectual property work for you. So this is the theme around which I'm going to address certain aspects. Of course, in India, it is at a very nascent stage that is yet to see the popularity. Of course, we had certain cases like Kingfisher, which was known or famous or infamous, whatever way you want to say, for other reasons. The creation of security in IPR asset, there are various aspects related to it. And in fact, of late, there is a trend which is increasing, and particularly in the COVID also, our finance ministry has also come out with certain particularly proposals that this will be an area which will be focused, and SMEs will be also in a way they can also put their IPR assets, they can create more IPR assets for their financing needs. If you have to understand what exactly is how this particular regime will be working, we need to understand how the traditional lending works in India or in any part of the world. In the traditional lending, we offer movable property, particularly immovable property, which is of course a tangible property. And that if I'm a borrower, I offer my property, and the bank, obviously a lender, will mortgage it as a collateral property, and they will lend it to me. Now, when it comes to intellectual property, how a security works. So security interest generally arise pursuant to an agreement between a creditor and a borrower, where the creditor requires more than just a commitment to repay. So now the commitment will be through the collateral interest, and that will be created in your IPR property. The intellectual property rights can be various way, or you can say there are different segments of IPR assets which I will be taking. Particularly proposal of IPR security as an asset was addressed by UNCITRAL through the legislative guide. The UNCITRAL legislative guide observed that the security rights over IP may be created by written agreement between the borrower or guarantor and secured creditor. So this was taken ahead, and the India, of course, addressed it in 2016 by way of National IPR policy. The main objective of National IPR policy was to enable valuation of IP rights as intangible assets by application of appropriate methods and guidelines, which will facilitate the securitization of IP rights and their use as collateral by creation of enabling legislative, administrative, and market framework. And to unlock the IP assets through commercialization, which in turn can bring a liquidity for those companies, whether it is MSME or any other company, who wants to have some liquidity by offering their IP as an asset. Now, if we say the IP assets, then which are the IP assets, or what are the types of transactions for creation of security in IP assets? Let us try to understand. The very first, if I will say, it is a very popularly known as mortgaging, where the borrower retains ownership but simultaneously grants an interest of the IP to the lender. The second would be licensing, where the lender takes ownership and then licenses it to the borrower. The third will be definitely the revenue which is generated from an intellectual property can be used by borrowers as a security on a loan. However, mostly what we are seeing is the first and the second part, which is the mortgaging and the licensing, which is more popular. Then if I will take it to the OECD, that the OECD has also laid down certain IP-backed financing, which they have created, which focuses on direct collateral, securitization, the sales and leaseback, and venture debt. So the collateral in the context of IP is considered as a borrower's pledge of a specific property, such as future cash flow from existing IP assets or rights to the underlying IP itself, in order to provide recourse for the lender in the event of default in the repayment of the loan amount. If we see which type of intellectual properties are there for creation of security, then of course there are the traditional IPR. The traditional IPR would be patents, trademarks, copyrights, and designs. Here I must mention that these traditional IPR have their shelf life, or they need to be renewed as the law provides. As my previous speaker also highlighted, that the shelf life of particular copyright or the patent or the design has to be again seen, and when it has to be renewed for the purpose of creation of the security in the IPR asset. Then second would be the rights created due to jurisprudence or the common law rights, which is not in the Patent Act or the Copyright Act, the Design Act, or any other law, but due to the jurisprudence or the common law rights, that those are trade secrets, confidential information, and goodwill. Third would be, definitely, it cannot be discarded, that the sui generis forms of intellectual property, such as plant breeders' right and semiconductor integrated circuit layout, which is again very new, particularly in India, and it is yet to see the sunlight. Now, if I will say that is okay, there are assets which can be created as a, or it can be offered for creation of a security in IP right. But what are the judicial or what are the legislative framework which supports such creation of security? Then definitely we have got to refer to the generalized law as well as special law. If I will say what are the general laws, then of course those will be Companies Act, SURFACI Act, and the contractual acts, whereas the special laws will be, of course, the Patent Act, Design Acts, Trademark Act, and the Copyright Act. Let me share with the Companies Act. The Companies Act, of course, provides that a company may create a charge on its property or assets or any of its undertaking, whether tangible or otherwise, and situated in or outside India. Here is a catch. It is not that if it is a property, even your IPR property, which is registered outside India, you can offer them as a security in India, unless they are also registered in India. So that will be a big challenge and a gray area unless you have registration, as the jurisdiction plays a pivotal role when it comes to creation of security on your IPR asset. Then the SURFACI Act, which deals with creation of security during the time of debt restructuring security interest, which is of course defined to mean any right, title, and interest of any kind, whatever, upon property created in favor of a secured creditor and includes any mortgage, charge, hypothecation, assignment, and other than those specified under the Act, and more particularly Section 31 of the Act. Now, the term property is well defined, as well as security interest is also defined under the SURFACI. Let me share for the benefit of all the attendees today that the security interest is meant to be the title, right, and interest of any kind whatsoever upon property created in favor of a secured creditor and include mortgage, charge, hypothecation, assignment. Then we need to move to the special laws. The special law, of course, the Patent Act provides that contemplates the recordal of the security interest, whatever is created by an assignment, license, mortgage, or otherwise. When it comes to the trademark and copyright, definitely they don't have a categorical provision, but Section 37, if I will say, of the trademark definitely allows a proprietor of a registered or unregistered trademark to assign his rights in the said trademark, either with or without the goodwill associated with such trademark. Again, there will be a gray area, because though the law, the trite law being, even this, you have unregistered trademark, then too you have a right. Even in the copyright also, it is not particularly registered, then too you can have a right, subject to certain sine qua non and satisfaction to the court of law if the dispute arises. But for the purpose of creation of security in the interest, definitely, though there is nothing specific as of now in the framework, but obviously it has to be registered. Otherwise, the bank will be reluctant to create any charge over these unregistered trademark or particularly copyright. Now, the Design Act definitely again provides in similar manner like Patent Act to mortgage license, and thereby it can be also created. Now, there are certain copyrights. The gray areas would be, if I have to brief, that what will be the gray areas where the legislative framework is yet to see, that is how it has to be acted upon and how this particular regime will be implemented as a reality, though we have a IPR policy in 2016, and during the COVID also, there are again a recent talk to create a framework for the particularly offering of loan on the IPR asset, but there are a lot of things which still needs to be addressed. But at the same time, let me also share one particular aspect under the income tax also. The goodwill is also considered to be an asset. So that whereby you can have the depreciation also. And the similar way, the RBI has also come out with certain guidelines, but those guidelines are still at a very nascent stage. The many more exercises, many more committee reports are yet to come on the floor. They are yet to see the daylight. And beside that, definitely the accounting standards, whether the AS 24, 26, 28, those definitely addresses that the how the intangible assets are recognized and they are to be carried out in the balance sheet. Having said that, there is a very important aspect connected with security on your IPR asset. That would be insurance. Just like any immovable property which is offered for any sort of mortgage or as a collateral security, there will be a very big requirement of insurance of these IPR assets, as the risk will be again associated with these IPR assets, whether due to the infringement, or there can be various aspects where the rights have already been assigned to some other person which cannot be traced. Unfortunately, we don't have IPR exchange, what is a very good model existing in UK, or the registration on a particularly IPR register, just like in other parts, maybe I think it is in Canada. So those things, unless are prevailing in India, there will be a lot of chances where the IPR, though assigned for availing the loan, but there can be litigations in these cases. Let me also share one case in the Canara Bank, what I can recall. The Supreme Court in that case has held that the defaulter cannot assign the trademark after a default has already taken place, because there was nothing like assignment of the trademark to the bank at the time of taking the loan. Subsequently, court held now it cannot be assigned to the bank, as the bank is to carry out the banking activities and not to indulge in using this trademark and to sell particularly commodity. In that case, of course, it was agarbatti. So the bank is not going to sell those type of trademark agarbatti and all. That is another gray area. Then I will quickly wrap up. Another area will be definitely the banks as well as the borrower both have to see the time limit, then the legal validity. The time limit and the legal validity has a very big interplay. And just Professor Dave has also highlighted the IBC. Recently, there was a matter where we had opined, though that matter was settled before that could be filed as an application in the running CIRP. There was again a very this type of thing where that as soon as the default will be there, the trademark will be assigned to a particular person from whom the loan was initially taken. That was not the person and not in the CIRP proceeding also. So during the CIRP proceeding, the RP could detect, yes, there was an agreement where this trademark was already assigned to the third person and who is not in any way connected either with the company, but fortunately it was the subsidiary company. So that was taken in a different manner and the matter got settled they had waived due to some other complication in other cases. Arbitration was also going on in some other manner. So that was curtailed, but those things will definitely be coming, and there will be an interplay between IBC, of course, IPR, arbitration, especially looking to how the structure will be framed for IP financing in India. And that is what I have to share, as the topic is very wide, the time is the challenge. So I will conclude with this.
Thank you very much. That was a very good presentation. Maybe I can ask one quick question. And the question really relates to the gray areas that you have mentioned. It seems that there are quite a few gray areas in India when it comes to how do you give notice of recantation? And can you maybe clarify a little bit more? For you, it seems like for patents, there is a well-defined path.
Yes.
So what do you do in India? You would basically file a recordation like you do it at the Indian Patent Office of the security interest. Is that what exactly? Let's say I get a security interest. What do I do next in India so that the rest of the world knows that I have a security interest? What do I do? What can you please explain that?
See, the framework in India is, if I will talk about patent, of course, you know that you have rightly pointed out the patent, there is a different regime. You have a lot of module, even it is published and everything is there. But as soon as the trademark particularly or any other contravention or any infringement is there, then definitely the notice, that is what is firstly being served. And then if it is not resolved, then we have to file for an injunction in the court of law, and seeking for injunction against the person who has infringed infringement, you take action. That is what the limited things available as a remedy.
I see. So there is no registrar where you can put
that is the only, if the person tries to register, say whether it is a patent you have already taken, there are two ways, that is the pre-patent grant or the post-grant opposition that you can file. And the trademark also, if some person has tried to apply for a registration of the trademark, you can, that is published, you can of course file a notice of opposition. Those are the things. I was on the infringement part. So these are the things.
Okay, thank you very much. So let's move on to the next speaker. Our next speaker is Professor Sudipta De. Ashwarya, can you please introduce Professor Sudipta De, please?
Yeah.
Sarkar. Professor Sudipta De Sarkar.
Thank you. Professor Sudipta De Sarkar is presently the Associate Dean at KIIT School of Law, Bhubaneswar. He's a full-time faculty there for more than 10 years. At the school, Professor De Sarkar teaches full-term papers on law relating to technology transfer, intellectual property management, intellectual property transactions, and litigation. He has a keen interest in learning and teaching transactional aspects involving IPR and has delivered lectures at Odisha Judicial Academy, Biju Patnaik State Police Academy, and other institutions in the state of Odisha. I welcome you, sir. And he would be talking on the subject of perfection or registration of security interest in IP asset.
Thank you so much for your kind introduction. And very good evening to Professor Dave, Professor Ramakrishna, my esteemed panelists over here, and all the esteemed members who have joined the session. So I was very brief presentation to share, and if I'm allowed, I would like to go ahead and share it. Excuse me, just take a few more seconds. Yes, so after the creation of security interest, it is the next step is perfection. And from perfection, we move on to enforcement, and that's how the flow is. So what do we achieve by this concept of perfection? Well, we achieve what we can say as a superiority of rights in comparison to others. So basically, what are we looking at? We're looking at perfection as a process where the secured creditor is basically completing his claim of a security, and which makes it fully effective to secure the debt with regard to the claim, and it kind of establishes the claim of the creditor on the asset. And this perfection can is not just limited to intellectual property asset. We can look at other kind of assets as well. So it also completes the claim on the collateral. So once it is perfected, the creditor is in a position to claim or repossess the collateral, securing the loan in case of a default. And that always is one of the areas which is there in the mind of the creditor, is that how do I realize, or how do I possess, or how do I liquidate the collateral in the event there is a default, realize the debt due. And as Professor Ramakrishna said at the beginning of the lecture, it also serves as an encumbrance, or serves as a notice of an encumbrance on the collateral. Now, as intellectual property rights, we all understand, given the different nature of the rights involved. In some where registration is a mandatory process, in some where registration is purely optional, in some where registration gives us some additional benefits. There itself, there is the registration process of the intellectual property itself as a nature of the grant, that itself serves as a notice of the nature of the grant itself. But this nature of the notice of this perfection process, this serves as a notice that on this intellectual property, which is serving as the collateral, that exists in the nature of an encumbrance. And as Professor Ramakrishna also said in the beginning, that this happens to take care of a lot of, or tries to avoid a lot of fraudulent transactions, when the same collateral could have been pledged or mortgaged to more than one creditor. So in this instance, we can say that just creating the security interest is not enough. We have to take a step ahead. We have to move ahead and go ahead with the perfection process, where this is recorded, this is publicized, and it is also available for search. That is one thing what we'll also be observing when we look at the Indian statutory provisions. Most of these documents, once registered on the register, it actually is available for search by anyone who is interested, which in turn is one of the major areas, ways how this fraudulent way of using the same collateral can be avoided. It alerts future creditors in case the person who is the original owner of the IP intends to conduct any kind of transaction involving the same collateral. The fact that the nature of the encumbrance is recorded, this alerts any kind of future creditors with regard to a previously existing charge on the IP asset. And finally, we can also look at priority, where perfection is connected to priority. Now, priority, what are we looking at? A priority of interest based on the priority of perfection, as compared to, for example, a secured creditor versus unsecured creditor, or a secured creditor with a perfected security interest versus a secured creditor with an unperfected security interest. Now, there are exceptions where a subsequent secured creditor may have a priority over a previous creditor, But on the overall, very generally speaking, you can say that perfection and priority can be called one leading to the another, which itself is one of the benefits why we can go ahead with the perfection. Now, moving to the next slide. Modes of perfection, again, very generally speaking, perfection by filing, perfection by possession, perfection by control, and one of the methods known as purchase money security interest. Now, most of the perfection that we will come across is by perfection by filing, as perfection by possession is ruled out in a lot of type of assets, including intellectual property, and definitely where possession of the asset is necessary in the hands of the debtor, not the security creditor, for further use of the property. So perfection of filing is one of the most commonly used ways of perfecting, including intellectual property. Now, if you're looking at perfection by possession, I would like to say that, for example, money and negotiable instruments, the fact that there is a perfection of that instrument is by means of the possession of that instrument by the creditor. Similarly, perfection by control, for example, deposit accounts, they are subject to control by the banks, and perfection is through the process of control. Purchase money security interest is something we often find in consumer practices. Now, moving to the next area. For perfection in India, we can have two broad areas. One is registered mortgage, one is equitable mortgage. For registered mortgage, also which we are referring here as legal mortgage, the title to the IP must be transferred to the lender pursuant to the mortgage document, ensuring that all local formality requirements are met. And for the registered IP, the transfer of title will need to be recorded at each relevant IP registry, that is under the controller of patents, designs, and trademarks. So under registered mortgage, it will also be the responsibility of the lender to maintain the IP by renewing any necessary registrations in order for its security to continue to be protected. Now, if you're looking at registered mortgage as compared to what we'll consider later as an equitable mortgage, a registered mortgage is much safer because it also involves documentation, recording of rights at the sub-registrar's office. And this is not what we are exactly talking to IP also. We are talking with regard to general property law also, where registered mortgage would require a specific recording of rights before the sub-registrar. That, of course, involves a lot of more legal time, or you would also say additional stamp duty and related things. But if you're looking at the title per se, then a registered mortgage definitely is going to be more secure than an equitable mortgage. But in a lot of banking transactions, we find that equitable mortgage is a more preferred route, where a lender will take possession of the relevant certificates and title documents, in this case IP, in other cases the property documents as well. And the mortgage instrument or the primary loan instrument will include the agreed terms as to any triggers when further steps may be taken to perfect the security interest. Moving further, now we are looking at specifically the recording of rights under Patents Act, specifically with regard to assignments. Now, one thing what we can notice here is that we have, like my earlier learned speaker said, patents and designs on one hand, and trademarks and copyrights on the other hand. Now, why are we making this division? It's there in the statute itself, which specifically is talking about assignments. For example, here, section 68. An assignment of a patent or of a share in a patent, a mortgage, license, or the creation of an interest in a patent shall not be valid unless the same wherein writing and the agreement between the parties concerned is reduced to the form of document, embodying all the terms and conditions governing the rights and obligations and duly executed. So this is a formality. In the sense, this needs to be adhered to. At the same time, that is why we have highlighted here the term mortgage, or even creation of any other security interest. So the statute here is permitting the creation of a mortgage on the patent, or even creation of any other interest in the patent. And then it is laying down the procedure as to what needs to be followed thereafter. So when any person becomes entitled as a mortgagee, I have actually removed some parts of the section which was not exactly relevant to this context or in this narrative. So when any person becomes entitled as a mortgagee, otherwise to any other interest in a patent, he shall apply in writing in the prescribed manner to the controller for the registration of his title, or as the case may be, of notice of his interest in registered. And this is where we are beginning the perfection procedure. And if we are going to read it along with section 72, subject to the provisions, the registrar shall at all convenient times be open to inspection by the public, and certified copies sealed shall be available on payment of the prescribed fee. So the fact that this is open for inspection should serve as any kind of person who wants to look into the nature of the collateral, whether there exists any mortgage or not on this, is it's possible for him to avail of section 72 and go and have a look at to what kind of existing encumbrances are there with regard to given patent. Now, these are similar provisions which will also be looking at in the Designs Act. For example, with section 30, clause 2, where any person becomes entitled as a mortgagee, licensee, otherwise to any interest in a registered design, he can make an application to the controller to register his title, and the controller, on receipt of such application and proof of title to his satisfaction, cause notice of the interest to be entered in the prescribed manner with such particulars, if any, creating such interest. And this is very similar to also section 68. And likewise, the Designs Act, this recording of this with the controller, this is also accessible to the public for any kind of inspection. Now, if you look, if you had patents and designs on one hand, which is specifically talking of mortgage, licensee, or any interest, then we come to trademarks and copyright. Now, trademark is now talking about assignments of copyright. Similarly, copyright law is talking about the assignments of copyright. Trademark law is talking about assignment of copyright. They are not mentioning anything about mortgages. They are not mentioning anything about interests. So if we have to work within these four walls of the statutory provision, we have to begin with the term assignment, and then we have to look into the fact whether this can be the ground for creation of any kind of security interest or not. So, for example, in the Indian Copyright Law of 1957, section 18 and 19 describes the assignments of copyright, which must be duly signed by either the owner of the copyright or his agent, and describe the agent of his rights assigned. Similarly, for trademark, section 6, every notification of assignment to be recorded in the Register of Trademarks, which is a publicly accessible document. And section 38 and 39, registered and unregistered trademarks may be assigned with or without goodwill. Now, section 38 and 39 form part of a chapter which deals more extensively with assignments. And if anyone is interested, can go to those provisions and they can have the provisions relating to assignments of trademarks. Now, without going into further discussion on this point at this moment, what I would be raising is one query, is that when these are different statutes, all statutory provisions, where patents and designs, we are looking at mortgages, and for trademarks and copyright, we're looking at assignments. Can we keep assignments as one of the grounds for security interest, or is that the legislative intent that for patents and designs, we can provide for mortgages, we provide for recording of any interest created in these, whereas for copyright and trademark, we are not looking at mortgages or creation of interests. Of course, copyright does have creation for licenses, but in copyright and trademark, we are looking only at assignments. So one of the questions, of course, here is that, was that the legislative intent? And if so, then what could be the reason? Now, coming to the very essential statute in India, the SARFAESI, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act of 2002, we have a central register which just a second. Yes, shall be kept at the head office of the central registry for entering the particulars of transactions relating to securitization of financial assets, reconstruction, and creation of security interests. And as per the definition, intellectual property is covered under the provisions of this chapter. The particulars of every transaction of securitization, asset reconstruction, or creation of security interest shall be filed with the central registrar within 30 days from the date of such transaction by the securitization company or reconstruction company or secured creditor. Of course, this time limit can be extended with discretion of the registrar. Now, addition to the securitization, the SARFAESI, we are also looking at the securitization rules of 2016, which is providing for that the particulars of creation, modification of security interests in intangible assets, being know-how, patent, copyright, trademark, license, franchise, etc., shall be filed in Form 1 or Form 2 as the case may be, and shall be authenticated by a person in the form of by use of a valid digital signature. So combined reading with SARFAESI 2002 and Securitization Rules 2016, this leads us to the central registry for filing of this security interests, which I have included in a slide here. This is the, we call it the CRSAI, C-R-S-A-A-I. That is the Central Registry for Security Asset Reconstruction and Security Interest of India. So if you go to that website, of course, the services have, they have to be paid to avail of this search. And if you go to the asset-based search and we click on intangibles, then we'll find a drop-down category which is detailing the recording of security interests, specifically the specific headings like copyright, patent, licenses. Even though I don't understand how they have kept IPR separate from the other headings, but still, I mean, if you want to have a look, or if any person is interested to have a look, then on payment of this due fees, we can go and have an asset-based search and understand the nature of encumbrance. In fact, there is also a company-based search. So there are different types of searches here in the CRSAI website, whichever one wants to avail of. So similarly, if a company is creating a charge on its own assets, including intangible assets in the nature of intellectual property, the latest Companies Act 2013 under Section 77 is stating that it shall be the duty of every company creating a charge on its property or assets, whether tangible or otherwise, situated in India or otherwise, to register the particulars of the charge signed by the company within 30 days of its creation. Now, the register of charge maintained by the ROC, the registrar of companies, shall be open to inspection by any person with regard to any of the charges created by the company. And if we move ahead, this is the nature of the form that is used to create the charge. And I've edited some parts of it because there have been a lot of intervening spaces with regard to other details. So we see that this is form number CHE1, and the area, that is 7, this is having specific mention of IPR charges in the nature of patent, trademarks, copyright, license under patent, goodwill, etc. Now, is it only limited to companies and creation of charges? The answer is no. We also can find a similar provision in the forms for limited liability partnerships, which we got in the Limited Liability Partnership Rules of 2009. If the LLP wants to create a charge on any kind of intellectual property, it's mentioned here: patent, license under patent, trademarks, copyright, and goodwill. So moving on, the first question is that when patents and design laws speak expressly about mortgage, why did not trademark and copyright laws speak about it, but they use the language on assignments? Now, can we use the term assignment to create what we can say security interest? Because assignment in its own terms would lead to a total transfer of right, title, and interest from one party to the other. Now, security interest also in the some of the definition used does also mean similarly that the transfer of right, title, interest in all forms whatsoever transferred. But there can be a dispute in the sense that if any person wants to construe security interest as not exactly a transfer of the entire right, title, or interest, but a transfer of the right to claim a debt, if they have to put a very limited understanding to this term of security interest, then on one hand, if I'm looking at assignment, this is looking at a total transfer of right, title, interest, but they are looking at security interest as a device to secure an indebtedness. I understand that there have been attempts to clarify this, that there are provisions to say that no security interest would mean a total transfer. But at the same time, I would also like to point out that there is a possibility that even though it's very much avoidable, that security interest can be given a broader meaning than just a device to claim indebtedness. Now, with regard to trademarks, there can arise a scenario where a secured creditor has been assigned the trademark with or without goodwill, but the secured creditor is not using the trademark for any kind of a on any product or any service as was being used by the earlier proprietor of the trademark. Now, if this secured creditor is holding the trademark in this capacity, then is there any kind of a risk that this person can be, or his ownership on the trademark can be held to be as a trafficking of marks? Will he have any kind of threat of that kind of practice as being called trafficking of marks? Simultaneously, I also came across certain suggestions that there could be a separate registry for IP security. So some countries probably have such kind of a security, IP security office, a separate registry. And given the fact that we have CERSEI, then in that instance, will that be at this stage where we stand with IP financing in India? Would a separate registry for IP security be of any help at the present moment, or is it something we can look maybe 5, 10 more years down the line as we get more used to these kind of practices? Now, moving forward on this, the fact that intellectual property has increased drastically as a result of the expansion, as we see that the intangible components of which IP is a very essential part has totally overturned itself from 1975 to 2015. So this actually is presenting a very positive scenario, not only for developed countries, but also countries like us in India and others where we are investing a lot in making it a knowledge economy. So it's my opinion and belief that if we can have some structured finance practices, definitely involving banks or the traditional financial institution, it is something we would be really be able to tap more into the potential, because that's how it is moving on. And this is some of the chart. I'm sorry, because of some of the font I cannot expand it, where this is some of the leading global banking entities and their exposure or their involvement in IP-backed financing by some leading global banks, mostly US-based. And there's also a certain trend which I noted that from 1980 to 2016, this had a cautious start. In the last 2 years, the patent collateral recorded by banks from 2014 to 2016 has suddenly seen an increase in activity. So is that something, or is it indicating that there is more involvement of traditional financing in patent collaterals or in IP collaterals, or if that can be replicated, or that can be a lesson which we can learn, and maybe we can also try to do the same or on similar basis in India. And by the British Bank, we had found this that in a type of loans we call enterprise finance guarantee backed loans, the default rate, which are backed by IP assets, they were actually much lesser, the default and loss rates, than the total traditional backed loans. So as a concluding slide, I have kept it very specific on 3 points. Number one is practices we have to develop, maybe implement, that the objectives of the National IPA Policy 2016, which has been referred by my earlier speakers, and I'm sure most of our other participants are aware as well, that if you're looking at a holistic implementation where IP financing is talked about and provided for, then I believe that the involvement of the traditional financing institution like banks is definitely a prerequisite. And in the event that is difficult for certain reasons, then maybe we have to be more involving the private lenders, the non-banking financial organizations. And maybe alternatives like IP securitization and others can also be looked into. Still, we are at a stage where the traditional financing banks can be part of the system. So similarly, understanding on part of the judiciary to the IP-specific needs and requirements of the IP financing sectors, which my earlier speaker also referred to the judgment in the Canara Bank case with regard to the limitation on banks, read with Section 6 of the Banking Regulation Act and Section 8 of the Banking Regulation Act, where they can conduct some kind of business activity which can be termed as the business of banking. But given the fact that if they are going to have a security interest, if they are going to finance, they might be have to look for activities beyond the strict interpretation of Section 6. So one thing I can request for, or we can definitely expect, is if the judiciary can actually give us a bit more flexibility to the strict interpretation of what a banks can do and what the banks cannot do, particularly with IP financing. And thirdly, as all these terms like perfection of security interest and everything, we have been relying heavily even to find the definition on very leading statutes like the Uniform Civil Code that's in the United States, and things like the UNCITRAL Legislative Guide on Secure Transactions Supplement. So these are some of the statutory instruments which we can definitely learn from a lot. And we have started from the SARFAESI and the other areas. We have brought in some kind of statutory measures and changes. But I'm sure that we can learn a lot, and these kind of acts, these kind of statutes can be the guiding force for us to have a better, more holistic IP finance system in India. So with that, I'll conclude my talk. Thank you very much.
Thank you very much. This was a very good talk. Very enlightening, I can say that. I have a couple of quick questions. Can I ask? Dr. Desai?
Certainly, sir.
Okay. You know, Mike, the thing that comes out clear to me sitting here in the US is when it comes to perfection, under US federal law, we can perfect the patents at USPTO, trademarks at USPTO, and copyrights at the Registrar of Copyright. And it's very clearly stated, as I explained in my presentation, in the law itself. The way you explained it to me is in India, the law is very clear with perfection of patents and design, so I call it. But when it comes to copyright and trademark, there's some ambiguity. Is that a correct interpretation?
Sir, actually, with regard to the situation in United States, with regard to Article 9 of the UCC, and where the federal law does not preempt. So I think under that ground, the copyright is permitted to be registered with the, what I would say, the copyright registry.
In India. I'm talking about is the ambiguity about where to register in India, copyright and trademark, because it's not.
We have separate for the grants itself. We have separate bodies for that. We have the copyright board for the copyright, and trademarks. We have the trademark registry.
I see. And where would you register a trademark?
We have the trademarks
where would you record a trademark? That's what I mean. Recordation of trademark. Where would you do that? In India.
We have the register of trademarks for that.
And you can once you do you would record the security interest at the trademark office. Is that what you do?
No, what we are going to do is we are going to record the grant of the trademark. We are going to record
that. I understand, but what about the security interest? Security interest. Where would you record the security interest on a trademark? That's my question.
And from my understanding.
Yeah. Go ahead.
From my understanding, I would say that in all probability it would be the SARFAESI.
That's SARFAESI, correct?
SARFAESI. Yes.
Okay, so that's what I thought. Now, question is, if you record, let's say, trademark or copyright under SARFAESI, does that amount to giving legal notice as per the statute? That's so does that constitute providing legal notice?
From what I understand about the SURFACE and the fact that it has to be recorded with CERSAI and it's available for public search at a payment, I think that would constitute a legal notice for the interested public.
It would. Okay. Thank you so much.
That's my understanding. It could be flawed,
Okay.
but
Has there been any case on that that says that, okay, this the recordation at SURFACE constitutes providing legal notice?
I am yet to come across any such case.
Okay. Thank you.
Thank
Very
you. sir.
good. Very. And your idea about a special registry for IP is obviously very good, but again, there has to be, it should amount to providing legal notice, and there should be a statute which says that this registry and recordation of security interest in the registry amounts to providing legal notice. That would be a key requirement. If such a registry.
In a country like India, and with level of our awareness and practices, that would be a very far-fetched idea, very honestly admitting, security registry for IP. But maybe something we can look forward to in the years ahead.
Yeah, I think it's a very good idea. Please continue pushing that idea forward. Thank you.
Thank you so much.
Okay. So the next speaker we have is Mr. Pramod Rao on enforcement of IP security assets, security interest. Aishwarya, can you please introduce?
Yes, sir. Mr. Pramod joined ICICI Bank as its Group General Counsel on August 16, 2018. He oversees the legal function for the ICICI Group. Previously, he had served as General Counsel for City India Cluster and was responsible for the legal and secretarial functions with the City India Cluster. He also oversaw City Security and Investigative Services and chaired the City India Diversity Council and was a member of various internal management and oversight committees. Mr. Pramod previously worked with the Indus Law, a law firm, as a resident partner, overseeing its banking and finance practice. He joined Indus Law in 2012 and was instrumental to setting up the firm's office in Mumbai. Prior to Indus Law, Mr. Pramod worked with ICICI Bank for over 15 years. During the course of his career at ICICI Bank, Mr. Pramod has overseen the legal function for all segments of the bank. During his time there, he also advised the board of directors and various board-constituted committees and served on the board of directors of various ICICI Group companies. Mr. Pramod presently serves as a member of board of directors of ICICI Securities Limited, ICICI Prudential Trust Limited, and ICICI Trusteeship Services Limited. He also serves as a member of the Legal and Banking Operations Committee of Indian Banks Association and of the National Committee for Regulatory Affairs constituted by the CII. I welcome you, sir, and thank you very much.
Would change.
Mrs. Sudipto, can you just stop sharing your slide so that Pramod Rao can share?
Sorry, I'll just close it.
Sir, actually, you're not audible.
Would this be better? Am I audible now?
Yes, sir. Yes, sir.
Yes,
All
sir.
right, my apologies. I'll just begin again. So I was saying that the topic took me back at least 20 plus years. It was in 1998-99 that we worked along with the firms Anand and Anand and Amarchand Mangaldas to actually create an entire financing proposition against security of intellectual property, spanning in fact all the types of security assets, intellectual property that were mentioned, and marrying the concepts, as it were, of both law of security and really intellectual property. So I will be delving into some of those as I talk through, and hopefully try and tackle some of the questions I heard many of the other panelists raise, and hopefully provide a practical perspective. So when it comes really to intellectual property and financing, I think first off, it's not for the weak-hearted. I think it has indeed got to have a clear understanding of what that intellectual property really represents for the economic enterprise. What is it that they actually, sort of I'm sorry, I seem to be getting some background noise. Hello?
Yes, sir.
Sir, kindly unmute. Sir, kindly unmute your.
Mr. Pramod, you are on mute.
Hello, is this better? Yes. Am I audible now?
Yes.
Yes.
I apologize.
Yes.
Somehow some background noise developed. Let me just dive deep into two or three aspects. I think one, indeed, the law of enforcement as to what governs. For banks, indeed, it is SARFAESI. I think a couple of speakers referred to it. The second would obviously be the DRT legislation, which governs and creates DRT as institutions for us to access. And for non-banks, in essence, it is the civil courts that we have to enforce, go for enforcement. Having said that, I think I wanted to actually double back into the 3 or 4 types of security that we take. There is obviously all of the traditional forms. There is mortgage, hypothecation, you can take a charge. And to me, I think each of the different assets that we talked about in intellectual property lend themselves to different types of security type also that we conceive of. So if I had to think about trademark, one would traditionally take it as either a mortgage along with the underlying business with which the trademark is associated, or for that matter, as a hypothecation. For us, both of these are, and to the point Dr. Dave was also inquiring, both of these, when they concern companies, are indeed registered with the registrar of charges, in the register of charges with the registrar of companies. So they act as a public notice. Clearly, while the Trademark Act itself doesn't talk about creation or registration of security interest, there exists a practice of the lender filing with the registry the notice about creation of security interest over the trademark. But for lenders at large or creditors at large and people dealing with the company, the Register of Charges acts as a notice, as I said. Equally, there is copyright. For copyright, normally we take it by way of assignment by way of security. Again, our assignment deed is stipulated and executed that assignment becomes absolute should there be a default. There can also be mechanisms such as escrow that we stipulate, where we safeguard the copyrighted materials so that we can have access to it when, if and when a default arises. Again, one of the practical things which arises is that we take even charge over the receivables that can arise over copyright from copyright materials. Those are by themselves valuable, and they may also be true for other security interests, for other types of intellectual property. Patent, indeed, I think the previous speaker mentioned both Patent Act and the Design Act actually recognize and allow for the notice being entered directly into the controller's books. So I won't dive deeper into that. I think if at all I had to articulate the challenges that are there, I think the primary one begins with valuation of IP. While the very first speaker spoke about that, there are the traditional means of valuation and so on, I think one of the key aspects to bear in mind is that, as a matter of fact, IP can also deteriorate in value over a course of time. It can be because of loss of market share. It can be deterioration of financials. When it comes to trademark, it could be a negative perception of the trademark itself. Involvement in controversies or legal proceedings. I noticed in the chat, one of the people had asked about Kingfisher and how bankers had taken security over that. So let me just describe that as an example. So when the security was taken by bankers, in fact, it was valued at greater than about 4,000 crores, right? All of the marks that Kingfisher Airlines had offered as security. When it came to enforcement, the reserve price fixed for that was not even 1/10, right? It was just about 300 crores or so. And even at that time, it failed to attract bidders because of the negative perception that had already developed around Kingfisher. But also the industry that that brand belonged to, right? It was affiliated or associated with the airline industry. Remember, Kingfisher is also a surrogate brand which is used by United Breweries. That is not the brand any bidder would have been getting. He would have been getting the brand only for airlines. So clearly the value had deteriorated, both given the industry context, but also the negative perceptions that had developed by them. The second, I would say, a challenge is inability to exploit the IP. So even if a lender gets possession of IP because of a default, but frankly, there are no players enough to sort of exploit that, or the lender itself lacks the expertise, then clearly the IP valuation might go for a toss again. So clearly that remains yet another challenge. Tangible assets such as land or factory and so on are finally capable of always finding a buyer at some price. But in case of a locked up industry, it may actually be difficult to trace buyers for IP at the time that you need it the most. The third challenge, if at all, I would say, is reluctance of buyers to purchase what is tainted IP. So again, remember, if I had to focus on just trademarks, the fact that a company has gone into a downturn may also erode goodwill and far more rapidly than one credits it with. So that also gives us a sort of reason for concern as to saying when the going is good, the valuations are very nice. When the going is tough is when really the valuations start to plummet. And therefore, it may not, again, it can put off both potential buyers and therefore put the creditors at risk as well. I think, again, a point not dwelled on much is that IPs exist for a limited duration of time. And when it exists for such a limited period, the danger which really arises is that if the lending is for long term, one can actually end up in a soup if those IPRs actually expire. Finally, there is two residual risks which exist, both in terms of trademarks, but also for patents, is that despite registration, these things can get reopened even after a period of time, right? So for instance, a patent can get revoked on the petition of an aggrieved person. A trademark is again available for cancellation if a person with an adverse claim emerges. All of these have the risk of putting the lender obviously at jeopardy, and that is something which we cannot sort of cater to if it is in normal course. With that, I wanted to switch gears and talk about 2 or 3 cases which have transpired in India in the recent past. Kingfisher Airlines, as I mentioned, there was indeed security which was obtained over its trademarks. And when enforcement was sought to be done, is when really the failure was quite visible. Both the auctions, there were 2 auctions conducted, did not attract any bidders at all. The method which had been adopted by the lenders in obtaining security was really by way of deed of hypothecation. So, we had talked about whether it can be mortgages, whether it could be any other forms. So in that particular case, the lenders had chosen the method of hypothecation over Kingfisher trademarks. The second example, if at all, which is available, is that of Deccan Chronicle. And let me assure the audience that both these cases do not give lenders any comfort at all. In Deccan Chronicle, again, the bankers had obtained security over the mastheads, over the newspaper trademarks. And when it was sought to be auctioned, there was an intercreditor issue. But thereafter, once the intercreditor issue was tackled and it was being put to auction, the promoters of this company ended up seeking an injunction from another court. And while the auction was allowed to be continued, and that the court reserved the right to confirm the sale, scared off any potential bidders, right? So again, to me, both the high-flying cases are also what I would say probably also mired in fraud. So it's not that one should, give significance, but these are the cases that are shaping our judiciary and the judicial reaction, so as to speak. I think I'd heard Mr. Mishra speak about the case of Canara Bank. Let me, as a banker, both clarify that judgment and therefore how we end up seeing it. The case actually involved where the trademark in respect of, as you said, incense sticks was assigned by way of settlement by the borrower to the bank. And the bank was actually collecting royalty in respect of that. The very fact that it was assigned in course of settlement and not that it was obtained originally as security is what resulted in the deprecation by the courts that it was beyond the purview of what a banking company could do in normal course. In more simpler words, what I would put it is this. Indeed, the bank is not meant to earn royalty from non-banking assets such as trademarks and so on. But when we obtain security, remember, enforcement of security entails that it is put into hands of a third party, right? That is what really a foreclosure or an enforcement of security entails. So had Canara Bank actually ensured that the incense sticks was the trademark over those were transferred to somebody who manufactured those incense sticks, that would have been perfectly correct. And that is exactly how a security interest is meant to work. So to me, that judgment is not really what I would call a challenge in financing intellectual property as the base for security interests. It is, however, as I said, colloquially thought of as if it prevents banks from doing so. It does not. Before I conclude, I would like to, sort of make a few more remarks, which is that startups and so on are actually those that require risk capital. Whereas what bankers end up doing is more financing for working capital or for extending long-term credit. For us, what we require are assets that really are valuable over those periods of time that we are extending finance for, or that if a default occurs, that indeed the enforcement occurs in a speedy manner to be able to realize the full value of that intellectual property. When that is not possible, I would say the lenders will shy away from extending finance against intellectual property. At the same time, is that valuable? Indeed, there are very valuable intellectual property getting created every day as we speak, whether they are in form of patents, whether they are in form of copyrights. There are brands and trademarks that have sprung over the years that have acquired enormous goodwill. And to us, we continue to finance those. And indeed, it is not new. It is not nascent in India. I'm assuring you that we've been at it for at least 20 plus years. It is just that it doesn't get as much prominence, and understandably so, that now that we have two high-profile cases that have not yielded great results for the banks. The two changes, if at all, in the legal framework that I'd like is just like the trademark, just like the Patents and Designs Act has specific provisions about charge. Indeed, one would like to see those for copyright and trademark too. But quite frankly, as I said, the Indian system of registration of charges by corporations actually captures that. And some speakers have mentioned about SERSAI. Indeed, that also under SARFAESI Act acts as a public registry. We don't need one more registry. Let me assure the audience and my fellow panelists, we have one too many in this country. I think we need to consolidate, and that is what I would sort of counsel. The second is in terms of easy availability and searchability of intellectual property, and to understand either ownership or security interest. That is something which, if it is indexed in the Register of Charges or SERSAI, that would prove far more valuable for all of us. With that, I'll pause. I'm happy to take any questions, including from Professor Dave, but also if anyone has it on chat.
Pramod, this was a very good talk from a very practical viewpoint as a banker. You are the one who is really dealing with money. And ultimately, it's all about money. We all should understand that. And let me, there's actually a very fundamental thing about intellectual property and securitization of intellectual property. And the fundamental thing is, and valuation. What is a intellectual property? What right does it give? It basically gives you the right to exclude somebody. It doesn't, unlike a piece of land or something, okay, where you can just use it for whatever it is. Here, your rights that you are getting is simply the rights to exclude somebody. Okay, and so I always say the value of an IP is in the eyes of the infringer. Now, think of it. If there's nobody who is willing to infringe that IP, what is the value? Value is zero, big zero. So if nobody cares for the word Kingfisher at some point, the value of the word trademark Kingfisher is zero, absolutely. If nobody is going to infringe a patent, the value of that patent is nothing but zero, big zero, okay? And especially in countries where the damages awards are almost close to zero, that means that even at some point, even if you are going to try to enforce the security interest, if there is a default, okay, how much can you recover from it? Possibly zero, if the damages are going to be close to zero. So it's a very interesting, what you just said is very, very important. What is the value? And the value lies in the eyes of the infringer. And if the courts are not going to award high damages value, you will, how can you give value, a good loan against somebody's intellectual property? Because they say we have a great IP. But in the US, the valuation is always done for IP is if there is a default, how much can you recover from people who are potential infringers. And if there's nobody who is infringing that IP or will be infringing that IP, okay, the value of that IP is close to nothing. And Pramod, I'm sure you have seen that situation.
Yes, I mean, I think of myself, if I was in the shoes of those bankers, I would have been sort of looking at that whom was Kingfisher most valuable to, right? I think it would have been most valuable to UB and to Heineken, the owners of that particular brand for beer, right? So would I have said that, since this is a surrogate item that you are using, why don't you take it back from me at a particular valuation? Because ultimately, at the time that it was mortgaged, probably the ownership was with Mr. Mallya and his holding company. But we knew that there's a larger interest which his beer brand had, which continues to use Kingfisher, by the way. So some of these, I think, require actual analysis of where the ownership is. I would take a classic example of a Richard Branson with his Virgin Group, right? Virgin is the brand that he attaches to whichever is the activity that he's doing. I think that has far more value, given that he might go into telecom versus, even flying people into space. But that is exactly the brand which has value. So would you not want that to be sold back to Richard Branson? Because he would understand if it goes into hands of somebody else that he might lose value of other enterprises. But yes, thought for another day. But what I wanted to leave with both you and the audience here, I can see some questions which I'm not sure are. Should I try and tackle some of them?
Are we running late? Maybe we should bring it back.
Yes, sir. We are running a little late. We are late by 15 minutes or so.
Okay. So
and
in that case,
of course, yes.
Go ahead, Dr. Ramakrishna.
So with the permission of the chair, may I collect some questions and put that to the conference speakers?
Please.
Thank you, sir. Thank you, Dr. Dave, for that. We have a couple of questions in the chat box, and we will have another 10 to 15 minutes for question and answers. Either dear participants, either you can put your questions in the chat box, or you can just open your video and shoot your question to concerned speakers. Either of these two could be the options. And we have a few questions which have come already, which I'll just read it out to the concerned speakers. This question appears to be a question related to valuation. So this is something which is directed towards Mr. Roy, Mr. Navari Roy. It goes like this. It is from Mr. Kodandaram, and he's asking this: when technological developments and changes in the trademark are dynamic, how is it possible to forecast sales and evaluate the future revenue that it could generate? Obviously, this go to the root of the methods of valuation, and I think this is specifically to the income method of valuation. May I request Mr. Roy to respond to this, please?
Sure. Yeah, thank you for that question. I think as a lot of the speakers have gone on to sort of talk about as well, there are, and like I mentioned as well, this is a sort of moving target, and the valuation would take place at that particular given moment in time and space. So like Mr. Rao as well mentioned, the brand and the value would be great when the going is good, but if it isn't going that well, or if there is negative publicity and things like that, that would automatically draw back the value as well. So it's just that you need to keep in mind that there are several factors that go into it, and this is just the moving target, or the nature of the asset as well is a factor that needs to be looked into. So in terms of whether or not you can arrive at a value, I would say to an extent and based on a lot of conditions.
Thank you, Mr. Roy. I hope that answers the question raised by Mr. Kodendram. We have yet another question in the chat box. I'll just put that to the speakers. It goes like this: is there any confidence left among Indian banks to use IP as collateral? What changes in law are required to increase the confidence among bankers? Of course, it's a very general question. It goes to the areas covered by all the speakers. I could request any of the speakers to come forward to answer that. May I ask Mr. Rao to respond to that, please, sir?
Sure. As I described, I think we both engage in financing against IP as assets, which are taken as security. So there is, it's not that we are scared of it. It's just that we have to be mindful of that there are certain things which can erode in value more rapidly than we think. There are others which can offer opportunity again. It's only that one has to think of it, and I think one of the speakers or you yourself used it, Dr. Which is to saying that you should have a known exit when you are actually engaging in such finance. Otherwise, you can get, have no buyers left, and that itself reduces the value to zero. So I think that that is something which I would say any lender has to bear in mind.
Thank you, sir. Thank you for the response. I think that takes care of the question. We have yet another question. This is a question related to security registry. So this question is directed to Professor Sarkar. Sir, I would request you to answer this. The question goes like this: are there any examples in other jurisdictions having any IP security registry? If yes, which jurisdiction can India learn from the most? So if you can just respond to this. Thank you so much. Professor Sarkar. Professor Sarkar says he is not able to unmute himself. So could we help him?
Yes, sir. I think now, sir, he can unmute himself. Yes, sir.
Professor Sarkar, please unmute yourself. It is allowed. It's permitted. Please respond.
Hi, thanks for the query. From what I best remember, I think China had some kind of a model with the IP registry, that own registration office with this for security interest. That's what I can remember.
And the model you yourself suggested is also, as the Professor Dave was telling, goes a long way to protect the interest and take care of the situation.
Honestly, yes, it's a suggestion, but it will take a really long time. Like everyone is saying, yes, let us consolidate where we are first, and then we can think of separate registries for IP.
Yeah. This is we are at a very early stage of development. We'll have to wait long to see a realistic picture of the theme we are talking about.
Yes,
thank you.
Dr. Lawal, I also came across your suggestions on this point, so it was also very enlightening.
Thank you so much, Professor Sarkar, for that. We have yet another question. This is something related to trademark, but it goes to the root of the very situation. This is a question from Mr. Kodendram again. The question, the first question was also raised by Mr. Kodendram himself. He's asking whether any caution what are the cautions that a lender should take, should exercise at the time of lending, while speculating, he's saying, considering such a situation for future time, while valuing the asset. Is this not a parameter to be considered as a best practice before lending? I think as a banker, I could request Mr. Rao to respond. So if you could just please.
Sure. I think, when it comes to valuation, we already heard Mr. Roy talk about the methods of valuation and so on. I think really what just one needs to look at is what are the worst case that can happen. And as I described, that there have been situations that have happened which need to be factored in as we go forward into doing it. Again, there are some things which might appreciate over a period of time. If I had to think about copyright and certain assets like that. Trademark is associated always with the business of the company and the goodwill it enjoys. So clearly, that can take a knock if the business has taken a knock. So that is something to bear in mind. Patents, again, can increase in value depending on how productive it is. And to Professor Dave's point, if there are people interested in infringing on it, you know that it has value. So probably patents as well. But remember, it has a limited shelf life. Again, within the period that Indian courts take to enforce and deliver verdicts, it could very well be that the patent has expired as well. So these are the items sort of which I would say practically need to be borne in mind. I end up looking at it as that if it is just the equivalent of how we hear about patent pools, if there are a bunch of patents and they are over an extended period of time, that might make it easier. If it is copyright not over 1 or 10 works, but over 100 works, again, it gives you more comfort as a lender. So each of those play a role in how you both look at it and value it. I remember with one of the large media houses, we actually lent against their collection at that time of 3,000 plus, copyrighted works. And that was, they were just getting started. So it was not even as if, we had to say that that's all that they have. They were going to develop more with the money that we had advanced, which would have given us even more security in the years ahead. So each of these is a factor, is what I would say.
Correct. So we can now move to the next speaker. But I can tell you in the US today, when it comes to valuation, there are a lot of bankers who are doing IP banking. It's become a big thing. But I can tell you one thing. When it comes to valuation for IP, the bankers will always look at what will happen, how much can they collect in case of a default. Okay, that's the value they will give. And when it comes to how much can they collect in case of a default, it really doesn't, it boils down to is how much others consider this to be valuable, not the owner, the guy who owns the IP and he's giving you it as a mortgage. Obviously, Mr. Malia thinks his Kingfisher has huge value, but what does the rest of the world think is the value for Kingfisher? That should be the amount you should be giving as a loan, not what Mr. Malia thinks is the value of his brand Kingfisher. See, this is a very fundamental disconnect between giving loans against real property versus intellectual property. Do not give your, do not value intellectual property based on what the owner of the intellectual property thinks is his value. Think of what is the value, what when he will default, what others will consider to be the value. Okay, huge difference between valuation for IP versus valuation for real property. Anyway, let's move on to the next speaker. And that is exactly how valuation for IP is done in the United States. It's always decided based on what will be the value in case there's a default, and what will be the rest of the world think as the value for this IP. Okay, or an infringer would think as the value for this IP. In short, okay, let's go to the next speaker. And if that's okay, his name is Philip Worden. He was my former partner and at Pillsbury. Pillsbury is a 700 plus attorney firm, one of the top 50 firms in the US. I was there for almost 10 years, and Phil and I, we worked on several projects, and this is one of the projects that we worked on, which was really to multi-million-dollar deal where the collateral was all IP assets. So, Phil, we are already running late, so I would like to hand over. Do you want to introduce Phil? Anybody has? Please.
Yeah, Mr. Divyesh does it.
Okay,
he's good.
Please do that.
Good evening again. Thank you for giving me the opportunity to introduce Phil. Philip S. Worden is the partner of Pillsbury Winthrop Shaw Pittman LLP. Phil Warden focuses on commercial law and related litigation, the right of creditors, and controversies involving allegations of unfair business practices. Phil has been involved in significant financial restructuring and insolvencies and related litigations around the United States and in Asia, possesses significant experience in CPR and AAA arbitration matters, and has represented indentured trustees for municipal bond issues totaling nearly $2 billion in litigation. Represented the indentured trustee for 7 municipal bonds totaling 1.85 billion in litigation with the Insurance Commissioner of the State of California in the Executive Life Insurance Company case. Phil has served as lead petitioner's counsel in CPR arbitration arising out of the acquisition of the manufacturing division of the New York State Exchange Company. Now I invite Philip S. Warden to deliver his address.
Thank you. Thank you.
Yeah, so
Let me.
Phil is one of the top bankruptcy lawyers in America, besides many other things. Phil, please. It has always been my pleasure
Yes,
to
sir.
work with you.
Let me describe, just to put this in context. We've been talking theoretically. I've been listening to this excellent presentation for some time, but I want to now get down to a real situation that Dr. Dave and I were confronted with a few years ago. We represented a very large computer and phone manufacturer who had learned of a new metallurgical process that was very strong and very light. I was, for example, given a paper clip and I was unable to bend it, made out of this metal. So what the client wanted to do was to use this technology for computer cases and specifically for iPhone cases, which would be much stronger. The owner of the technology, however, was not financially strong. Why was that? Well, he had some applications for the sale of his alloy, military for gun barrels, and for drill bits, but we didn't want it for that. He would not sell us the technology. So what did we do? We took a license in about 100 patents. And inasmuch as we thought that his financial situation was fragile, we took every precaution that we could think of. So what did we do? We took a security interest in the patents. We got the pertinent trademarks and the copyrights. And what was our fear in the US and in many Asian and European countries, a trustee in bankruptcy or a debtor in bankruptcy, a debtor in possession, can reject or lawfully breach an executory contract or unexpired license. So what we had were 100 patent licenses that we'd paid a great deal of money for, but we wanted to protect ourselves. We paid a lot of money up front. So what are the devices that we used? We set up a bankruptcy remote entity. What's that? It was an entity that was separate from the licensor. The licensor had other creditors. The licensor had litigation. The licensor had some problems. So what did we do? We transferred all of the IP, all the patents and copyrights and trademarks to this bankruptcy remote entity, which had no other business. So it was sterile. It was free of these other problems. We incorporated it in Delaware, and then just to be really careful, we took a pledge of the stock of this BRE. We set it up completely separate. And we also wanted to guard against something that bankruptcy trustees and debtors can do, which is called substantive consolidation. We did not want to have our rights, our license, our investment compromised and consolidated into a common pot with other creditors so that they would share. So again, we kept everything completely separate, and it's consistent with what you folks have been discussing this morning. We took a security interest in everything. We took a security interest in the patents. and we took a security interest in the copyrights and the trademarks. How did we do that? Well, in the US, typically the way you perfect a security interest is under state law, and you perfect via what's called a UCC1, a financing statement, which is a public record that describes the security that you're taking. So we perfected, or we took a security interest, we got a grant, and I know you folks have been discussing grants of security interest. We got an outright grant of a security interest in all of the IP. And then we perfected both under state law with the Secretary of State of the state of headquarters of the licensor, the debtor. And we also perfected in the patent office and the copyright office. How did we do that? We wanted to protect against bona fide purchasers. And we did so. We filed memorandum. And so at the end of the day, what did we have? Well, we had extensive security documentation. Did we insert, this is something that lawyers often ask, well, shoot, Phil, can't you simply put in a clause that if there's a problem, you get certain rights, you're automatically, the debtor has no interest, or certain other things that cure automatically. Those don't work under the bankruptcy code, so-called ipso facto clauses, those that have a negative result to the debtor automatically. Those simply are void. So after the end of all of the work that Raj and I did to perfect a security interest under both state and federal law, we created this bankruptcy remote entity. We took a pledge. We did everything we could think of. So what happened? The answer is nothing happened. That's the good news.
So let me, Phil, maybe I can stop you here for a minute, if you don't mind. Also tell them, not only we did record and perfect the security interest in the US, there were so many worldwide patents, and we had to go all over the world perfecting the security interest. Now, this becomes very tricky because every country has its own different laws, okay? So you have to then make sure that you understand what are the laws for recordation and perfecting the security interest in each and every country. And it was the whole process, and what we did was a huge task. So can you give them some idea about how much work we put in for this one single deal?
I probably shouldn't disclose the amount of the bill, but I will say that
you can sort of tell them that too.
It was a lot of work to perfect all over the world. Gets awfully expensive, but in this case, here's what the client's risks were. If we spent a lot of time obtaining the technology, and then we had to set up a foundry to actually produce the metal for our specific application. And then we had to market the idea that we had a superior product. So how much money was at risk? Well, the answer is hundreds of millions of dollars. So what did we do? We perfected in every country where we thought there would be a problem, where the client had a major presence and where the debtor, the licensor, had previously or was currently licensing the technology. As I mentioned, we took a specific license in specific fields of use, not a general license, specific fields of use for the applications that we or the client wanted to use. So did we take a license to make gun barrels with this alloy? Of course not. And did we take one for drill bits? No, we excluded all that. But then we did, as Dr. Dave says, we did go around the world and we took measures to perfect our security interest in all of the major economies of the world. I hope I've answered your question.
Yeah, thank you. And
Okay.
in terms of how many hours of work did we put in?
I think 400.
Yes. So these type of projects are not small projects, I can tell you. It took us 400 hours to do this task of getting these arrangement done, getting the bankruptcy remote entity created, perfecting the security interest. It's a lot of work and a lot of time it takes. Please continue, Phil.
I think we're running fairly short on time, so let me give you, again, putting this in a real context. If I created a hypothetical, if there is a licensee in India and it wants to license, say, software from a USA entity, and even the strongest companies in the US occasionally get into financial trouble. Pacific Gas and Electric is a good example. That's the largest utility in California. It's been in bankruptcy twice in the last 20 years. It had, I think the plan was $53 billion. So even the strongest companies get in trouble. So what did we do? What can you do in that situation? You can protect yourself much as Raj and I did previously. We took a security interest in the intellectual property that was the subject of the license. We made sure that there was a written security interest with a grant, an outright grant of a security interest in my example in the software. And what are we securing? I think in the last hour or so, I listened to the various speakers' presentation, and we talked about money. In our case, and in the situation Dr. Dave and I worked on, we weren't securing money, we were securing performance. We wanted, what do you do when you get a software license? What do you want? Well, you want the unfettered use of the software. You want the licensor to continue to upgrade, and most importantly, I think, debug, i.e. make your software actually do what it was designed to do. And he's got to protect you against anybody that alleges infringement or tries to interfere in some fashion. So what did we take a security interest in? Not money, but performance of all of the duties. We also, of course, perfected under both state and federal law. Some people could tell you, well, for a patent or software, all you need to do is file with the state Secretary of State. I don't believe that. And it doesn't cost much to go ahead and perfect in the Patent and Trademark Office. And that's what we did. And that's what should be done. And the other thing that can be done, if there's a lot of money involved, is to put all of the IP into a remote entity to guard against the notion of consolidation and to protect yourself from other creditors. And then there's one final device that I've used particularly with software, and that is, remember, when you get a software license, you typically get object code, not source code. Well, why is that important? Well, if you need to debug or upgrade or enhance your software, you need source code. But will the licensor allow you to have that? The answer is no, they won't. They're very jealous of their technology and they don't want you to see that. They don't want you to have access to it. So what do? Well, we created a source code escrow, and there are various entities. I mentioned one of them called Iron Mountain. And the big four accounting firms often will act as source code escrow. So we created an escrow, and the source code was held in the escrow. So here's what happens in Silicon Valley more often than it should. Companies, software developers often run into financial trouble, and they simply close their doors. I think in the a nomenclature of the industry, they throw the keys to the landlord. So what do you do as a licensee? What can you do? What are your remedies? Well, if you didn't have a source code escrow and the developer, the licensor, simply went out of business, you'd be stuck. You'd have a product that you may have paid a lot of money for, and you'd have nothing to show for it. So we escrowed it, and the way the escrow works is if you, for example, go to the licensor and say, I need some help. I need you to help me work out some bugs. And if the licensor doesn't respond to you very promptly, then that triggers your rights under the source code escrow to have access to the actual source code. And those are some of the things you can do. Let me mention, because somebody I'm sure will ask this because it's well known. In the US, the situation of rejecting executory contracts and particular source code, or excuse me, copyright licenses and patent licenses became so prevalent that the Congress enacted a few years ago an amendment to the bankruptcy code called Section 365N. And what that does is it allows you to continue to use the technology that is the subject of the license, but subject to some fairly severe restrictions. But here's the problem that it at least in part alleviated. If you pay $10 million for a license on day one, and then your ongoing license payments are, let's say, $1 million a year. The trouble is you've paid most of the money up front. And so if after 2 months, the licensor files bankruptcy and then says to you, hey, Mr. Licensee, I'm going to reject. I'm going to breach. I'm going to lawfully breach this license, and you'll be left with nothing. You'll have no rights. You won't have the right. So what the Congress has done is said, no, you can make an election to continue to do that. However, the licensor may be out of business, and it no longer has to support you or help you debug or amend or otherwise enhance your license. So there are some rights to protect against rejection, but they do have some important limitations. With that, I think we're out of time.
Thank you so much, Phil. I think we had a very good discussion today. There was a lot of theoretical discussion ending up with Phil's real practical life experience that he has had. And I can tell you, as I said at the very beginning of this is a very difficult area because it requires you to understand two very difficult areas by itself, which are IP and bankruptcy. And unless you combine the knowledge of the two, bankruptcy and IP, it's going to go wrong. I can tell you one thing, it's going to go wrong. And how do you put it in practice such that you protect in scenarios? Remember the two hypotheticals I gave you. The first hypothetical is the one that the owner sells it to A, and soon after that, owner declares bankruptcy. Okay, that's exactly the scenario that Phil has referred to. And how do you protect against that? By you creating a vehicle like the bankruptcy remote vehicle entity. And the other thing we discussed, a scenario I presented is owner of the IP, sells it to buyer A, and then he also sells it to a bona fide buyer B. In that case, who gets the rights to the IP? Okay, there we have to really look at the whole process of who has the perfected rights. So I think we have really discussed pretty much the complete gamut, and I think our speakers from India have done a fabulous job in also explaining how it works in India. Is there, Professor Ramakrishna, any comments from you, please?
Yeah. Before we conclude, I think as Professor Dr. Raj Dave said, this particular roundtable was really a very, very useful, insightful, roundtable. for various reasons. As Raj Dave said, there was input from the academic perspective, and then there was also exposure to the practical issues that come up, that which are going to be handled by the patent attorney on the one hand, at the same time by the bankers handling IPR, banking regulations, the bankruptcy regulations. So a combination of all these, right, has been addressed too. I fully agree with Raj when he says that this is one of the complicated, tough areas to address. And I remember Dr. Lavalman, who just spoke, right, took up this particular topic for his research some 6 or 7 years back when none of these were major issues in India. I started working on that. So this is when we got interest in it. And recently we had a debate just 2-3 months back, me and Lavalman. Then we thought this is the right time for us to explore the nitty-gritties in this, the legal framework and the regulatory framework surrounding this, to learn from the best practices from other jurisdictions, to learn from people who have actually addressed these issues. For example, Dr. Dave, he started with a practical hypothetical scenario. And he said how we can handle this particular situation and what is the outcome of that. And Phil took us through his own experience of how it could be handled. And, Pramod Rao, incidentally, I am happy and I am proud that Pramod Rao is an alumnus of National Law School. He was trying to address from his perspective, trying to say that these situations could have been handled in a better manner, right, than the way it has been handled in certain situations. So the very practical approach to this. And we also came across two divergent opinions here. One, whether we should have a separate registry. Pramod Rao says we have enough registries and therefore there's no question of adding any more of these registries. But then these type of debate, discussion ultimately would end up in some concrete structure, evolving some concrete structure in India. From that perspective, I think the participants are benefited. We, the organizers, are much more benefited from this particular program because a lot of learning has happened at this particular juncture. Let me, on behalf of the National Law School of India University and the Center for Intellectual Property Rights Research and Advocacy, extend my thanks to all the learned speakers. Navare Roy, right, in his own unique, typical style of presentation, right, took us through the whole IP due diligence process and the nuances there. And Mr. Ananda Dev Mishra was again looking at the process of creation of the security interest. Mr. Sudipta Sarkar looking at the perfection of it and taking the examples of other jurisdictions. Pramod Rao, of course, sharing his practical experiences. Right? Then, of course, the highlight I always keep saying, when Raj is there, there is more room for discussion. There's more room for intense issues that come up, to which Raj would lead, and that has happened here. And in fact, when I sent a message to Raj to find out whether this area we can identify someone or the other, Raj said this is a very simple thing that we have been handling it for decades in US. And then he said, I can get a team of experts. Something going back to Mahabharata, right? Whether you want Akshauhini Sainya or you want Krishna. With Akshauhini Sainya, I said, Raj, you should be there. Right? He has been there and he's been with Phil also. Thank you, Dr. Raj and Dr. Phil. We from our center, not only thank you, but also we would expect further cooperation in building up this particular discipline of IP security as a security and securitization of IP also. We just want to build jurisprudence in this particular area and develop and do conduct some studies in this area. And we require the support of all of you right here afterwards. As far as the roundtable is concerned, we have dedicated rapporteurs who have noted down the views expressed by each speaker, and that will be consolidated, and we're going to share that with the respective speakers. And I would request the respective speakers to kindly get back to us with whatever changes you would like to suggest, whatever additions you want to make to that particular report, so that at the end of this, we are going to publish the report of this particular roundtable, which would be helpful to many who is in the practice, many academic scholars, etc. So once again, let me thank all of you. Especially, I thank Raj Dave for having chaired the session and conducted the program effectively. Thank you very much.
Thank you.
Thank you, sir.
Thank you.
Respectable speakers and distinguished guests and my dear participants, on behalf of DPIIT Chair on IPR and CIPRA NLSU Bangalore, I would like to thank each and everyone for participating actively for this session, and a special thanks and a heartful thanks to all the learned speakers for their time and also for valuable insights. And I would like to thank Professor T. Ramakrishna sir for giving us this opportunity and also encouraging us all the time for conducting such activities. And once again, I thank you each and everyone for sparing this continuous 3 hours of the time and actively participated in this session. Thank you one and all. Have a nice time.
Thank you. Thank you, Nana, for all the coordination. And thanks, Levelman.
Thank you, sir.
Thank you, everyone. Thank you so much, sir.
Thank you, Sudipta. We'll stay in touch.
Sure, sir.
And continue to do more research and activities in this area.
Yes, sir, definitely.
Yeah.
Thank you so much.
Thank you. Thank you, Phil. We'll be troubling you.
Thank you.
Thank you very much.